Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican for his service luncheon.
Is that correct?
I didn't ask you to interrupt me.
Literally not true.
Oh, for Trump's sake.
All right, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. My desk's a little tall, a little blurry, and I didn't comb what little hair I have left this morning, so we'll just tuck it up under the headband, make it look good. Good morning. Hope everyone's doing great. Happy Thursday, Podcast Thursday as well. Greeners comes in and says, let's do this. Greeners, my friend, congratulations. You were first in chat today. As you've been first in chat many days. You knew what was coming to you when you did this. So I don't feel bad sending you to internet ownership. Excuse me. What's up, Doc? Okay. I don't feel bad sending you to internet ownership at all. Zero bad feels whatsoever. I'm good with that. So, deserve it. Anyway, let's go. All right, how is everybody doing? Happy Thursday. Not everybody's doing just absolutely great here in the RA household, but you know we're getting by. We're getting by. I need a Friday badly, Mindy. You and me both. Can today be Friday? And then just have a whole bunch of Saturdays in a row. So, all right. Sick. Thanks for asking. Oh, I'm sorry, Scent Bunny. That's no fun. That's no fun whatsoever. How's everyone doing though? Other than those of us that are a little under the weather. I say us, even though it's not me. Is the right one? That is the right one. Okay. Keep an eye on that. We have a little hearing we might be jumping to this morning. It's a hearing. Not sure. I have the flu and it sucks. Oh yeah, it was bad this year. It was like a 2-week long flu. Sometimes it's like 24 hours. This was 2 weeks. Great, just got back from Amsterdam. Now have a cold, but that's okay. Fabulous place, says Objection. Had a blast. Show pictures. The mountain cedar is kicking my butt. Allergies? Is that what it is? Allergies in January? All right. Let's see. Let's get some birthday celebrations underway, so we can start the party that way, and then we'll jump to court and take a look-see and a listen and see what's happening. Cedar fever is a thing in the South. Oh man, it's terrible, absolutely terrible. Perforated eardrum, you'd hate it. Sounds like I'm underwater. I have had a ruptured eardrum. I will tell you, having the ruptured eardrum was very preferable to what came right before having the ruptured eardrum, which was the bulging eardrum, where the entire side of my face, like you couldn't touch like my cheek without causing pain with my eardrum. That's how sensitive it was. Oh my goodness, so much pain. And you know how I'm such a baby over pain. All right. Yes, I'm in Texas. It's bad. They actually call it cedar fever. Wow. Never heard of it until today. I was today years old when I heard of cedar fever. Possibly going to Mr. Michael's hearing. I think, or maybe not. There's also a Nikita Kassup having a hearing right now that we might look at. I'm not sure. I haven't dug deep into these. All right. Happy birthday to Alexis Lucy Goosey, Mary Jane, Sandy C, and Xavion. I think I said all those perfectly, so we're going to go ahead and sing to them. Everyone stand up wherever you are. Deep breath, shoulders back. Project your voice to the back of the room. Blend your voice with your neighbor and warm up with me if you will. La 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 la. Happy birthday to you. Happy birthday to Alexis, Lucy, Mary Jane, Sandy C, and Xavion. Happy birthday to you. Alexis, Lucy, Mary Jane, Sandy C, and Xavion. Happy birthday. There are many wonderful days, but today is your special day, and I realize there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully you can turn that joy back to you, make your day just a little bit specialer. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. Happy birthday. Allergies till I moved to Missouri. I'm from the land of palm trees and sand. I had allergies out in the Mountain West, but it was mostly like ragweed and stuff that would do it for me there. Eventually cats. Yes, I did get a little bit of an allergy for cats. Not as bad as some of my siblings, or my children actually have some pretty bad ones. Greeners member for 32 months says I need to reevaluate my life choices. But not this one. Greeners, congratulations, my friend. 32 months makes you, in fact, an OG. The old original Greeners of all Greeners. Their OG stands for Greeners, original Greeners. Welcome, my friend. It is not the same when you are not here. I appreciate it. I'm going to clip this from my grandson, Xavion, and my daughter, says Denisha. That's awesome. Make sure you get this part, because we're doing the drum solo. Ready? Make it snap. Beautiful. I really think that if I had a real drum set in front of me and did those same hand gestures that you just saw, you would have heard the same thing you just heard in your ears. I'm that good. Nailed it. It's the only song I can play, but nailed the drum solo. There we go. Welcome one and all. It's great dancing as well. Yes, great dancing. It was fantastic. Let's see.
Happy birthday.
Samantha says,
you look good.
Davion Michael is sentencing decapitation of boyfriend. Ooh, that sounds quite final. Nikita Kasip is expected to plead to 2 counts of murder and mom and stepdad to fund a violent extremist plot against the U.S. government. Okay, so we'll keep it quite pickles today. We'll keep it pickles and go to the extremist plot against the government. What do you guys think? Anybody? Can we do that without it being a problem? Mrs. R.A. is in a little bit of back pain today. Well, when I say a little bit, I mean I would probably be shriveled into a ball the size of a pill bug and screaming in pain, and she's just, teaching homeschool through it. So it's been a little bit of a rough night, and I'm a little bit tired. So we need to find something we can watch that will keep us entertained. Adjust the lumbar. Yeah, I wish it were that simple, but and the meds are barely taking the edge off. What did I do? It wasn't me. No. She got it for her birthday.
Happy
she had her birthday and she
You
got
look
back
good.
pain. So she's a hero. She's amazing. Then bam, she got old overnight. That's what happened. She got to be my age, and now she feels what it's like to be my age. So good times. Isn't it great getting old when, things that we took for granted before, like being able to get out of bed without, worrying if you're going to make it 2 steps to the door. Yeah, fun times. I needed new water. This one has a hole in it. It all leaked out. Good morning. The jump from my 20s to my 30s was a huge slap in the face, says Abby. Chug. I'm just trying to stay hydrated. Red Pen says, I slept wrong the other day, and it took 3 days to unkink my neck. This is funny. When I was a kid, like babies, you guys can relate. If you had children or you've been around children, you can relate. When they are very young, they can sleep in any position, like folded over backwards over the arm of the high chair at dinner. They're out and just perfectly happy, no problems whatsoever. Just sprawled out on a hardwood floor. That they can sleep anywhere. Now for me to sleep, first of all, I can sleep very easily, but to go to sleep, I used to make fun of like dogs that had to like turn around like 3 times before they would lay down. And I'm like, what? You can't just lay down and sleep? No. Now I'm like, okay, where's the big pillow? I need the big pillow, and then I need the soft one and the medium one, and we have to arrange them on the bed and get the blankets just so, and like put my back into this one just like this. And like going to sleep is now, it's a whole assembly line has to be completed so I can get in my sleep position. And then of course, once you've done all that, and you're like, okay, I did it, and it's perfect. It feels great. The pillows are right, and you're like, and I left the light on. It's way over there. And now I have to get back out of bed. And I know I can't get back in the same position. It's like, should I just sleep with the light on? No? Is there something wrong with that? I need the clapper. Yeah. With all the tech I have, you think I could remote control my light somehow. That would be good. All right. Anyway, fun time. Motion for an RA sleep stream. Oh, my goodness. I probably need to do a sleep study. And then you have to pee. Yes. Well, you get the light off, then you have to pee. And then you stand up and you kick something because the light's off. It's a whole thing. I'm glad all of you guys can relate to my daily pain. I should just make everything a smart light, right? Just put it all. But then when the internet goes off, I won't be able to find my way around my house. I'll just be in the dark. Jinx, I'm jealous. I'm jealous if you have smart lighting throughout their house. It's cool. It probably saves you money, too, honestly. Usually smart lighting is LED instead of incandescent. Although a few people still have incandescent bulbs or fluorescents and stuff. But they're generally cheaper to run. And, the smart lights I guess it can detect when you're in the room, too. Get the smart lights. Okay, Gracefully Broken Mom, I'm with you. But I think on a priority level, I should probably first have a ground wire installed in areas of my home. There are parts of my house that do not have ground wires, electrically speaking. I still am on wire and tube wiring in my upstairs. It scares me to death, especially now that we've got like all this running in a 3D printer. We're sucking some serious amperage through these 115-year-old wires. All right. The studio's grounded, right? It was. No, I think it is. I think I'll have to check the lights on the surge protector. Probably not. Knob and tube. Yeah, that's it. Let's see. Where are we? You're dad. You can ground it instantly with one says you're grounded. That's pretty much what we have right now. But I will tell you this: everything that is new in the house, so now 2 bathrooms and 1 kitchen, is properly wired, like with somebody who knew what they were doing. So I did not do the wiring part. I did the bathroom actually. I wired the bathroom, but I had to FaceTime an electrician to make that happen. All right. I like living on the edge. Yes. All right. Where are we at? Do we want to go to the hearing for the plots against the government killed the parents to enable the plot to tear down the government? Is that where we want to go to hear that hearing this morning? Might be a guilty plea, might be short. Yes. Let's go back and take a gander at that and see what happened in that world. I think it's an 8. It is. Okay, this just happened a bit ago this morning. Just give us a minute to get it together, and I'll get some better audio for you as well.
Mr. Ruffel?
Yes.
Okay. I'll call the matter. State of Wisconsin versus Nikita Cassidy.
Oh, that sounds terrible.
25 CFA by attorney Paul Ruffel and Colton Ham.
All right. Good morning, everybody. The
Let's-
matter is here today
let me see if I can
for
clean
a
this
change
up.
of plea hearing. I was advised prior to the holiday break that there was some type of resolution of the matter, and that it was the intent of Mr. Cassip to enter pleas of guilty or no contest to counts 1 and 2 in the information. I subsequently received a plea questionnaire and waiver of rights form and other materials that were consistent with that. Is that, in fact, what's going to happen today, Mr. Ruffel?
It is, Your Honor.
All right. Ms. Basie, has the state complied with victim notification requirements, ma'am?
We have, Your Honor, and I believe that there are several victims via Zoom.
That is my understanding. Although we don't have them on video, I understand they are appearing by Zoom. And so that's, I'll find the state has complied with victim notification requirements. All right. So I'm going to talk, Mr. Cassip, I'm going to talk to you about the plea questionnaire and waiver of rights form. And I'm also going to ask other questions about your ability to communicate with your attorney and how much time you've had and so on. I'm confident that Mr. Ruffel has prepared you for those questions. And I'm also going to ask Mr. Ruffel about the review of discovery and so on. I'll ask the state as well about providing discovery materials, the nature of the materials, and what's happened in that regard. So let's start with that. First of all, Ms. Basie, are you confident that in every respect you've complied with the discovery process and provided all materials to the defense team?
Yes, we have been in contact with the defense. We've met several times in terms of things that they were missing or they couldn't open. I think that all of those have been corrected and were submitted to the defense. I believe in speaking with the defense, they acknowledged that they believe that they had a full packet of discovery.
All right. And Mr. Ruffel, what about that issue about discovery? Are you confident that you've had the opportunity to receive all the materials that the states had available to it in this case, sir?
Yes, Your Honor.
Okay. All right. So, Mr. Cassip, I'm going to talk to you now about this plea questionnaire and waiver of rights form and all the other documents that I've received. First of all, I want you to understand that according to this document, it indicates that the state's offer in this case is upon a plea of not guilty, other than not guilty, excuse me, to counts 1 and 2. In other words, a plea of guilty or no contest to those counts. On or before February 19th, and not filing other motions, the state would dismiss and read in the remaining counts. And at the time of sentencing, both sides are free to argue as to what they believe to be the appropriate sentences. Is that your understanding of what the state's position is?
Yes, Your Honor.
All right. And is it your understanding, sir, that you and your attorney are going to be free to argue for whatever you believe to be an appropriate sentence or sentences in this matter?
Yes, Your Honor.
And is it also correct, sir, that you and Mr. Ruffel have discussed the parameters, that is, the extent of the sentences? That is, if you're found guilty of these 2 counts of first-degree intentional homicide, on each count it carries with it a sentence of life imprisonment without the possibility of extended supervision. Do you understand that?
Yes, Your Honor.
But on the other side, there is an option where the court could allow for extended supervision eligibility, not a promise of it, but the opportunity or eligibility for extended supervision after 20 years have you've served on each sentence. You understand that?
He's accused of killing his mom and his stepfather.
It's not a minimum, but it's the possibility exists for extended supervision after 20 years on each sentence. You understand that?
Yes, Your Honor.
All right. And you feel that Mr. Ruffel's explained that to you adequately?
He lived with their bodies in his home.
All right. I'm going to talk to you now about some of the other aspects of this plea questionnaire and waiver of rights form. Mr. Ruffel, you have a copy of it in front of your client?
I do.
All right. This tells me that you are 18 years of age and you've completed 11 years of school. Is that correct?
Yes, Your Honor.
These incidents interfered with your finishing high school, correct?
Yes, Your Honor.
All right. Do you have any problem reading at all?
I do not, Your Honor.
All right. Were you able to read and understand the documents that have been generated in this case? In other words, police reports, statements from witnesses perhaps, or other documents that have been generated in this case?
Yes, Your Honor.
And also, were you able to read and understand these documents that you've submitted to me with the plea questionnaire and waiver of rights form?
Yes, Your Honor.
This also tells me you understand English. That's why I asked this question about your level of education, because it's really not just how far did you get in school, but whether you were able to comprehend and understand all the materials that have been generated in this case. Do you feel you've had time to do that as well?
Yes, Your Honor.
Okay. Now, this says you understand the charges to which you're pleading, and in fact, you and your attorneys, I should say, have included with the plea questionnaire what's called the jury instructions for these offenses for first-degree intentional homicide. It's numbered 1010, and it sets out the elements of the offense that the state would have to prove if this case went to trial. Did you review that with Mr. Raffel?
Yes, Your Honor.
Do you understand what the state would have to prove if you went to trial in each of these cases?
Yes, Your Honor.
All right, we're going to talk about those elements in a little bit, all right? This also tells me you are not receiving any treatment for a mental illness or disorder. Is that true?
Yes, Your Honor.
Is it also true that you've not had any alcohol, medication, or drugs in the last 24 hours?
Yes, Your Honor.
Mr. Raffel, I'm going to ask you about as I always do, about the understanding of English and reading and so on. Mr. Kassup is 18 years of age, was 17, I believe, when you commenced your representation. Do you feel that you've had a sufficient amount of time to review with your client the discovery materials in this case?
Yes, Your Honor.
And there, I presume, were video recordings as well. Did you review those with him as well?
We did.
All right. Any doubt about his ability to comprehend or understand, or let me take a step back. Any difficulties whatsoever in communicating with your client?
No.
All right. So I'm going to talk to you now about your constitutional rights. This document that you have in front of you says, I understand that by entering this plea, I give up the following constitutional rights. Each right is listed here. There's a box next to each one. Each box has an X through it. Does that mean you've reviewed all those rights with your attorney?
Yes, Your Honor.
Does that mean you understand those rights?
Yes, Your Honor.
And does that mean you're giving up those rights?
Yes, Your Honor.
All right, tell me if this is true. It says, I give up my right to a trial. True?
Yes, Your Honor.
I give up my right to remain silent, and I understand that my silence could not be used against me at trial. True?
Yes, Your Honor.
I give up my right to testify and present evidence at trial. True?
Yes, Your Honor.
I give up my right to use subpoenas to require witnesses to come to court and testify for me at trial. You understand a subpoena is a court order that you and your attorney could get, and you could require witnesses to come to court on your behalf, even if they didn't want to. Do you understand that?
Yes, Your Honor.
Is it correct and true that you're giving up that right as well?
Yes, Your Honor.
It says, I give up my right to a jury trial where all 12 jurors would have to agree that I'm either guilty or not guilty. Is that true?
Yes, Your Honor.
I give up my right to confront in court the people who testify against me and cross-examine them. Cross-examine means that you and your attorney could question witnesses to test the truthfulness.
Yeah, we're having some issues.
And accuracy of what they have to say. Do you understand that?
Yes, Your Honor.
And is it correct that you're giving up that right as well?
Yes, Your Honor.
And then finally it says, I give up my right to make the state prove me guilty beyond a reasonable doubt. Is that true?
Yes, Your Honor.
And did you discuss the concept of what it means for a reasonable doubt?
Yes, Your Honor.
Your attorney talked to you about that?
Yes.
Any questions about these rights, sir?
No, Your Honor.
Anybody in any way force you to give up these rights?
No, Your Honor.
All right, let's take a look at the charge against you, sir, or charges, I should say. Count number one in the information alleges that on or about February 11, 2025, at an address on Cider Hills Drive in the village of Waukesha, Waukesha County, Wisconsin, you did cause the death of victim A, who's identified as Donald Mayer, M-A-Y-E-R, with intent to kill that person, contrary to Wisconsin law listed in the information. What is your plea to count one, sir?
Guilty, Your Honor.
Donald is 51 years old.
Count number two says on the same date and location, February 11, 2025, at the address on Cider Hills Drive in the village of Waukesha, Waukesha County, Wisconsin, you did cause the death of victim B, who's identified as Tatiana Kassup, with intent to kill that person, Contrary to Wisconsin law listed in the information, a Class A felony, what is your plea to that charge, sir?
Guilty, Your Honor.
All right.
Tatiana was 35.
Did you
That was his mom.
commit these offenses?
Yes, Your Honor.
So as to count number one, as to Donald Meyer, did you intentionally take some action? My understanding is that you used a handgun, a pistol, or a revolver, and you shot him and caused his death. Is that correct?
Yes, Your Honor.
Did you do that intentionally?
Yes, Your Honor.
And you knew that shooting him would cause his death?
Yes, Your Honor.
And as to count two, Tatiana Kasep, and the same questions for you. Did you take an action? Did you use a handgun to shoot her and kill her?
Yes, Your Honor.
Was that your intent, sir?
Yes, Your Honor.
You admit you committed both of these offenses?
Yes, Your Honor.
It's very
Ms.
in-depth.
Basie, you offered the complaint
Change of plea.
originally filed as a factual basis?
I do.
All right, any objection, Mr. Raffel?
No, Your Honor.
Do you understand, Mr. Kasep, on your pleas of guilty, I will find you guilty. If you're not a citizen of the United States, your pleas could result in deportation, the exclusion of admission to this country, or the denial of naturalization under federal law. Is that clear?
Yes, Your Honor.
Furthermore, because these are felony offenses, you may not vote in any election until your civil rights are restored to you. Do you understand that?
Yes, Your Honor.
And because these are felonies, it's unlawful for you to possess a firearm. If you ever possess a firearm, you could be found guilty of a serious offense resulting in up to a 10-year term of imprisonment and a $25,000 fine, or both. Do you understand that?
Yes, Your Honor.
Furthermore, this is a violent felony. It's considered, of course, a violent felony. Therefore, it is unlawful for you to possess body armor as well. Clear?
Yes, Your Honor.
Also, where these charges, the other charges, are going to be dismissed and read in, it means I'll consider that you committed those offenses. I'll hold you responsible for them, but you will not be found guilty or sentenced for them, although I could also order that you pay restitution as well. Do you understand that?
Yes, Your Honor.
You cannot be prosecuted for those in the future. Do you understand that as well?
Yes, Your Honor.
And you understand if I find that your plea is knowingly, freely, and voluntarily made, I will find you guilty. Your pleas. Do you understand that?
Yes, Your Honor.
All right. Have you had enough time to talk to your attorney about everything?
Yes, Your Honor.
Are you entering your pleas and giving up your rights freely and voluntarily?
Yes, Your Honor.
Do you have any questions for me or for your attorneys at this juncture?
No, Your Honor.
Mr. Raffel, have you had enough time to talk to your client?
Yes, Your Honor.
And do you believe that he enters his pleas and waives his rights freely and voluntarily?
Yes, sir.
And again, I'll reiterate the question. Do you feel at any time that there has been any kind of impediment that would prevent him from understanding you as you discuss the matters with him? Of course, I'm not asking for any confidential or privileged information, but were there any impediments, or is there anything else you feel needs to be done before we can move forward, or before I could accept his plea, sir?
No, Your Honor.
All right. Ms. Basie, you've indicated that you've complied with victim notification requirements. Is there anything you think I'm overlooking or omitting at this time as we go through this process?
I do not.
All right. And I've asked to use a criminal complaint as a factual basis, and I've heard Mr. Kasep make admissions to committing these offenses. Is there anything else that you need to put on the record as a factual basis at this juncture?
No, Your Honor.
All right. Mr. Kasep, do you need any more time or have any other questions for your attorney?
No, Your Honor.
All right. I'm going to find that Mr. Kasep has knowingly, freely, voluntarily, and intelligently waived his rights and entered his pleas. I'll find a sufficient factual basis based on the contents of the complaint originally filed in this action and his admissions in court today. I'll find him guilty of counts 1 and 2 on the information. You move to dismiss and read in the remaining counts, ma'am?
Yes, counts 3 through 9.
All right, counts 3 through 9 are dismissed and read in. Again, I'll enter that finding of guilt. We understand that the court is obligated to impose life sentences in these cases, but the issue of whether or not there's going to be an opportunity for eligibility for extended supervision after a 20 years period of time is an issue for the court to take up. Mr. Raffel, what do you want me to do at this point in terms of sentencing? How much time do you need, and so on?
Your Honor, we had originally set early March for the trial date. I'm asking that we schedule sentencing where on one of the days where we had trial scheduled.
Okay.
That's in March. They want sentencing till March?
Give me one moment.
It's a long time to wait. I guess that's a 90-day PSI then?
How about March 5th? I believe that's a Thursday.
It works for the state.
Is there anything better, AM or PM? I've set
AM.
half a day.
I also want to check with the victims to make sure that that works for them as well.
All right. Please, well, I expect it would because that was a trial date, right? So please do.
If on that afternoon we're available.
All right. 1:30. Tentatively March 5th at 1:30.
It's fine. Thank
All
you.
right. March 5th at 1:30. Bail is revoked at this time, and he's to be remanded to the custody of the Waukesha County Sheriff's Department until the time of sentencing. Anything else from the state?
No, Your Honor.
Anything else from the defense?
No, Your Honor.
All right. Good luck, everybody. Thank you.
Thank you.
That's what murder will get you. Life in prison. But he has an opportunity for parole, which is fortunate for him. Could have been worse. The other charges were dropped as part of the plea deal. He was accused of killing his parents to get money to fund his extremist views, which included assassinating a sitting president. No, I don't think he was out on bail. I think he had I think he was in custody the whole time. What's going on in Washika? Not Washika, but Wisconsin. Judge Simpson. Hang on.
Banbury on Zoom?
She was here.
She has not checked in.
No, I saw her this morning.
You saw who?
I thought I saw Miss Banbury.
Going back up together. It's tense. Do you recall whenever you feel like it?
Veronica Glenn on behalf.
Those people I've ever seen. No, I respect my answers.
Take your hat off. This is Mr. Allen.
Veronica Glenn on behalf of Miss Burnberry. Can you please?
Your name?
Deja Monique Banbury.
Thank you.
Your Honor, we're requesting adjournment in this matter.
Do I have a green sheet?
Yes, I think so.
Any objection from the people?
Mickey Mouse has made an appearance.
January 29th, 2026, 9 a.m. 5 continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus James Cobbs.
Assistant Public Defender Davy Lebo on behalf of Mr. Cobbs, who's approaching. Mr. Cobbs, can you tell the court your name, sir?
James Cobbs. Thank you.
And, Your Honor, we would like to set this matter for preliminary examination, please.
Discovery complete.
It is, Your Honor.
Is Mr. Allen flexing, or is that just...
People have their witnesses available the 20th.
We'll do our best, Your Honor.
Preliminary examination in person, January 20th, 2026, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case People versus Manuel
Barnthouse.
Barnthouse.
Here, Your Honor.
You're still going to have to say your name.
Veronica Glenn on behalf of Mr. Barnthouse, who should be appearing by Zoom.
Yes. Sir, state your name.
Manuel Barnhouse.
The T is silent.
What are we doing on
Your
this?
Honor, we would like to request an adjournment in this matter.
Why?
Reason for the adjournment, I don't have a brief.
There are some new charges.
New charges? That's always bad. Could just be additional investigation turned up more offenses, like if he's charged with Say, for instance,
Probable cause
robbing a
conference
bank.
will be adjourned to February
Other banks might have come forward and said us too.
2026, 9 a.m. Bond continued.
Generally
Your
not a
Honor.
good indicator.
Thank you, Your Honor.
Thank you, sir.
But he's out on bond.
Court
so he
does
can't
call the
be that
case People
serious.
versus Davian Gavin.
Samsung has gum.
Andrew Childers appearing on behalf of you.
Or breakfast.
Hello, Senator Dobby. On behalf of Mr. Gavin.
Other side. Switch sides.
Your name, sir?
Davion Lamar Gavin.
Thank you.
And Your Honor, we do have an agreement to waive Mr. Gavin's preliminary examination with an agreement to felony HIDA at circuit court.
So he's waiving.
Yes, Your Honor, and I'm having him execute the form now, and I have reviewed the relevant rights with him.
Sir, you're waiving your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, sir.
Examination having been waived, defendants bound over to circuit court. Single count.
Thank you, Your Honor. We acknowledge the information, waive formal reading, and stand mute.
Defendant having waived formal reading, standing mute. The court will enter a not guilty plea. Pretrial will be set for January 21st, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor. Mr. Gavin would like me to address bond.
Of course.
Go ahead.
Thank you, Your Honor. So Mr. Gavin indicates to me that his previous failure to appear, he had attempted to be present on Zoom, but didn't hear that his name was called. He does tell me that he would have stable housing, thing with a friend in Detroit. We would have no objection to a home confinement tether. Additionally, Mr. Gavin has let me know that he has 2 jobs that he would be working if he's released, one at Motor Casino, one at McDonald's. He does tell me his life is significantly more stable than when he failed to appear.
But he failed to appear in 2024.
Correct, Your Honor.
And we just
And
got
this
him
is
how?
2026.
It is, Your Honor.
It's a long time to fail to appear.
So what was he doing for
2 years?
Now approaching 2 years.
I was working. Like after they issued the bench warrant, I didn't know how to go about that. And so I started working at McDonald's right after. And
okay, so how'd you end up back in custody?
When we was driving, we was driving, and he got pulled.
Whenever a story starts that way, it's not going to be good. Go ahead.
No, he got pulled over because they was doing like 90, and he didn't have his license, and his car insurance was suspended, and I was going to get him, and when I pulled in, they was letting him go, and then they asked for my ID, and when I gave him my ID, and they said I had an arrest warrant, and
that's how you got to take it in. So if that hadn't occurred, we still wouldn't be seeing you. Yeah, there really isn't a need to answer that, but you wouldn't have come in on your own because you said you didn't know how to, even though you had attorneys. I don't need a response from the people. Motion for bond reduction is denied. Bond will continue.
Thank you.
Court calls the case People versus Jessica. Is it Brasgala?
Is that her? Samsung?
Brian Bowling on behalf of Ms. Brasgala, who should be present on Zoom, Judge.
Andrew Childers appearing on behalf of you.
Brasgala?
You need to unmute, ma'am.
She's Samsung.
Yeah, that is her, Judge.
Your name?
Jessica Brasgala.
Okay.
Your Honor, I'm asking for an adjournment for Ms. Brasgala to pick up and review discovery from my office. It's been
pick
prepared.
it up and review.
Yes.
I think did she spit out the gum or swallow
Probable
it?
cause conference January 29, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Did see
Court
Alan
does call
Jackson
the
drop
case
that
People
case.
versus Joseph Griffin.
Is the gum going back in the mouth? That's the question.
Griffin, who is approaching.
Your name, sir?
Joseph Burton Griffin, Your Honor.
Thank you.
Your Honor, requesting to adjourn this matter. We don't have any media in this case.
Pardon?
We're adjourning this matter. Our office has yet to receive the media in Mr. Griffin's case.
Discovery or anything?
Yeah, the discovery.
They say
And
we're
Your Honor,
adjourned.
we do have a disc as well as some video online. We just need to create the media notice and get that over to defense counsel, so it should be pretty short.
Okay. Is there anything else holding him besides these two cases, or? That was a question.
Oh, to me?
Is he being held on anything else? Because that's gonna.
His lawyers.
On his other cases, he's has an
Feel
order
pain.
for release to treatment, Your Honor.
Okay. So,
Seeing that does look as out of county holds from Van Buren, Williams, to Canton, 2 of those are bond denied.
got it. Okay. So, well, let me do this. Let me put these over to the 29th, 2026, a little bit further than I would, but he really wouldn't be going anywhere at 9 a.m. And his bond in these matters then will continue. Okay.
Thank you, Your Honor.
Thank you. I don't have green sheet, but I imagine he doesn't care. Yoo-hoo. Are we gonna get green sheets
Oh, yes.
like today?
Yes.
Did you already have them? No, don't, you're, okay. She at least told the truth. Court calls the case, People versus John Brooks.
Hannah Mackey on behalf of Mr. Brooks. Mr. Brooks. Who is approaching? Please state your name.
John Brooks.
Thank you.
Your Honor, requesting to adjourn this matter to continue negotiations. And I have the green sheet for that one.
The judge.
Thank you. See that.
Lots of people in court today.
Probable cause conference will be adjourned January 29, 2026, 9 a.m. Bound continues.
Thank you.
Thank you.
Cachette, Happy New Year to you. 2026 is going to be amazing.
Court calls the cases of the People versus Carlos Hicks. Please.
Sherilyn Foster Tucker on behalf of Carlos Hicks on cases 1294 and 2223.
Bailiff moved right up behind him.
On the other case.
He's got 3 cases.
There should be a substitution on file. Okay.
Yeah, you guys are on his other case.
Hannah Mackey on behalf of Mr. Hicks.
Your name, sir?
How you doing, Joe? My name is Carlos Hicks.
Thank you, sir.
Well,
Short Gain, Senior Assistant Public Defender, representing Mr. Hicks'
All right, what are we doing?
Your Honor, we did just receive this case. I've spoken with Mr. Cook. I know that there is some video discovery that he indicates he can get to us in the next couple of days. Mr. Hicks does want his cases set for exam.
Okay. But you haven't seen the video nor reviewed it.
Not yet.
So, like setting for exam, but you don't
then,
have all the evidence.
What do you want? And he would understand that if it doesn't get over there, that's not going to be the basis for an adjournment. You
That is
understand that, Mr. Hicks? Okay.
yes.
And I would, so that you know, for consideration, adjourn it 1 week and then set it after you get a chance to look at it and talk with him about it. So that's also an option for you.
Did you
Ms. Gaines, on his other matter, what did you guys want to do on that?
Your Honor, I believe it was previously set for a preliminary exam, but I did think
it
we
wasn't
had withdrawn from that case as well. So I'm just going to.
that his
Judge Dad was on this morning, but he's gone dark now. Looking to see if there's anything else.
and then he did he not appear? Yes. Okay, I see. So back in December of 25, he didn't appear. got a bench warrant. Who was that set?
Judge Wolf is on in Tennessee.
Okay.
This matter was not on our docket originally, so I have also not had a chance to speak to Mr. Hicks about that past history, but I did speak to Mr. Cook and
Right,
when
and
it's brought
so that I'm clear,
fellow counsel.
you were appointed on the matter that he bench warranted on.
On one of them, I think there were 2 cases set for exam, and I was on one. The public defender was on the other. And then.
Okay, right. Okay, so on 1294, that was the one he bench warranted on.
Yes.
You were appointed.
Yes.
And you're also just now appointed on 2223.
Yes, Your Honor. Mr. Bernstein was.
Right. You're off. Okay. And so you want those 2 set, and is it on 2223 that you don't have the discovery?
That is correct.
Okay. And Ms. Gaines, on his other case, does the PD believe they have a conflict? I mean,
No, Your Honor, as I'm looking at this next piece, that we withdrew from 3 of his cases, and I think.
And 3, you withdrew from 3?
Yes, and I think this may be the one that we kept. So as I'm looking at it, I think that's where, but I did not see these case numbers on the docket. So if I could have a moment to ask Mr. Hicks if he would still like to have this preliminary exam, go ahead and set it, because it had previously been set.
Okay. And, here's the other thing. And my next date is what? The 3rd?
Yes.
Okay, so just so you understand, his case has to come back to me. So it's not going to be set on the 20th. It's going to be set in any event on February 3rd. I think it's my next date.
So it's not me on the 20th. Do you want to adjourn PCC?
I mean, I'll set them all for that date, although the other one wasn't really before me, but to keep them all together, if that's what you guys want to do.
I don't.
Either way, you're exam.
Suppose if I don't have them, I don't
want your data.
You don't what?
Are you saying?
You guys might want to mute.
I'm living in the ozone. I'm living in the ozone, so I'm trying to get home quick so my bed won't be in jeopardy.
Oh, are those Mackie screen sheets? Is that what they are? While we had that break. Is that what those are? Oh, okay, great. I'll sign it.
Your Honor.
Where's she going?
She's speaking to someone who's.
To who? What?
Looking for more courts here. Just one second.
Oh. Nobody else would get away with this except Miss Gaines. Just walking away. If it had been anybody else, I would have yelled.
I'm so sorry, Your Honor.
No, you don't have to apologize. What are we doing?
Your Honor, I was just confirming, Mr. Hicks was indicating to us that he is a resident at Ozone House, and the Ozone staff is here present. And I was just confirming that they were here present. And we are requesting that while we are going to be making a bond argument so that he would be able to return to Ozone House and be required to follow whatever conditions that they have, as well as to come back to court. And he has drunk driving school tomorrow. Truck driving school tomorrow.
Oops.
Let me just say.
I'd like to go pro se lawyer.
Get me back in jail.
This is the day that I'm just going downhill, right?
She tried to get me back in jail.
No, sir. Mr. Hicks would never even think.
Hey, I don't
Under the
drink,
influence.
sir. I don't
Yeah.
drink.
See, that's
not a
all.
drinker. I'm really trying to do good, sir.
My lawyer's
apparently
throwing
he
me
went
under
to
the
school
bus.
for that. So,
There's a school for that.
do the
It's at the bar.
people have a position on bond? I mean,
You have to pass the bar.
Concerns given the previous failure to appear in the nature of the charges rather than.
And I'll be on tether, so
hold on. All right.
And Your Honor, I will indicate for the newest case, I did speak to Mr. Hicks. He has no reason to be at that resident. I think he doesn't live near that residence anymore, so he would understand that he's not to go to that residence for the newest case.
Right. Hey, okay, I get that, but
He wants to get out so he doesn't lose his spot at Ozone. That's a place that's helping
why
him
didn't
right
you
now.
show up? I mean, the problem I have is him not showing up for the preliminary exam. I mean, because all the witnesses, everybody's here, and then he doesn't show up.
That's not a good
How did he come back into custody?
So if I may start, Your Honor, he is indicating that at the time of the preliminary examination, he was homeless at that time. So his situation is substantially different by working with Ozone House and having a place to stay. Is that correct, sir?
yes. And they're gonna make
Okay,
sure
so I get that part, maybe.
show up to court.
So the other problem that I'm having though is how did he come back into custody? Was he picked up? Did the new case?
That is my.
Is it the new case that he came into contact with police, and then that's how we got him back on the warrant?
That is my understanding.
Otherwise, we wouldn't see him.
He does indicate that he tried to contact the court, but there was, I think it was about 4 days.
He's got attorneys all over the place.
Yeah,
I mean, he had you guys.
I had a
And
Friday, sir. I broke my shoulder, I dislocated my shoulder, so I was in the hospital. So I never had a chance to call him. So my plan was to call that Monday, but then unfortunately, I got wrapped up in another case. So I was trying to call, man. Please just give me this. So I won't.
Well, no, see, that's my problem. My problem is you don't appear, and it's one thing, I guess, if you don't appear at a PCC, although I don't like that either. But your case is set for exam. You don't appear. Then the only way that you get back here
you pick up another case.
Is that you have police pick up another case that they arrest you on that warrant. And so now you're held on more cases than when you didn't show up.
Yeah, I give you my word, sir, that I'll make sure
You gave me your word the last time. That didn't work. No, it didn't work. You didn't show up, and then you picked up a new case.
I did try to show up to court, but I just went to the wrong day because I had a lot of court dates. And now I'm
okay. Well, that's not a good thing to
They're
tell
gonna
me.
help me make sure I show up to the court. So they're gonna make sure you drive me, take me to the court. So I make sure I show up to court. And she actually here today. So
No, I know they're here, and they're good people. The problem is you have to be cooperative with everybody on this.
Yes.
And you haven't been cooperative with the court.
Yeah, I'll take accountability, and I apologize. As a man, I apologize.
Young man, I appreciate what you're telling me, but I don't see how in good faith I can let you go.
Please.
Thank you for the please, but I'm going to still tell you, in good faith, I can't do that. I would consider a written motion before the court so that everything can be considered if that's what you want to do. But I can't on the facts of what I see right now do that. I mean, and young man, so that you understand, and there was a gentleman this morning, same thing. If you're out, if you're out and you're out on bond, then you don't appear for your proceedings, and we don't hear from you because everybody has an attorney, and your attorney's not contacted. You're not doing anything to get back, but the only way that you come back before me is you're picked up on something else. I'm not letting you back out again absent extraordinary circumstance. Okay?
I understand.
So This one has to be set before me. My next date is the 3rd.
Yeah.
And because the preliminary examination that was originally set was before me, preliminary examination in all of these matters will be set February 3rd, 2026, 9 a.m. All of these will be set before me. At this time, his bond will continue. If between now and then you wish to file something, you know how to get to my staff, and we can try to set something if the time permits. All right. Thank you. Yeah.
Yeah.
Court does call the case People versus Bernard Brock.
Anna Mackey on behalf of Mr. Brock, who is approaching. Please state your name.
Bernard Brock. Thank you.
Your Honor, requesting to adjourn this matter. I haven't been able to get in touch with Mr. Brock to go over the media. Is there not a green sheet?
What?
Do you have a green sheet or no?
Nope.
There'll be one
This
soon.
seems to be something consistent with you today, Miss May. I don't know. I'm not blaming you. Well, I am.
So we're requesting to adjourn this matter.
I am blaming you.
No matter January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
You're welcome. We'll await the green sheet. Court does call the cases of the People versus John Hart. 3 cases.
Assistant Public Defender Davy Lebo for Mr. Hart, who stands to my right, and we do have an agreement whereby he'll be waiving. We do have an agreement he'll be waiving his exam.
On all of these cases?
Yes, Your Honor, if I could place the agreement on the record, please.
Go ahead.
Thank you. In the 25F55814 matter, the agreement will be that there be an offer at Circuit Court for a plea to count 1 with a dismissal of counts 2 and 3. In the 5854 matter, there is an agreement to a dismissal of count 1 upon a plea to count 2. And in the 1168 matter, there is an agreement to dismiss that case in its entirety upon pleas to the other 2 matters.
That's all.
And I have the waiver form.
Mr. Hart, you understand that you're waiving your right to preliminary examination in these 3 cases?
Yes, Your Honor, I do.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir, I do.
You understand you'll not have that hearing and that you'll proceed to Circuit Court for further proceedings?
Yes, sir, I do. I do. Yes.
For the
One
record,
other thing, I want to thank you for giving me the opportunity to do that. Because
I'm sorry?
I want to thank you for giving me the opportunity to do that because you've listened to me instead of just rushing me along. The whole time I've come in front of you, every time. You've listened to me, and I appreciate that. Thank you. And I'm going to Don Farms now because of you. Transitional. You wanted to send me to Hope, Mercy, whatever, but Don Farms is local, and I've been there before 5 years ago, and they're great. They're great. I appreciate you.
Well, thank you, sir, for saying that.
Did he bring his book?
I'm not sure what to say, but that means a great deal.
How about Go Blue? Huh?
No, that doesn't. That really can't. That's really hard for me to come out of.
I know. Thank you, though.
But I can say Go Terps.
For real.
But all right.
Have a good rest of the day. Thanks.
Well, hold on. We still got more to do here. So,
okay.
Preliminary examination having been waived, defendant is bound over in the case ending in 1168 on the single count. In that case, in the case ending in 4545, he's bound over on counts 1 and 2. And on the other matter, he's bound over on count 1 with counts 2 and 3 following.
We acknowledge receipt of the information, waive formal reading, and stand mute.
That's a lot of matters.
Defendant having waived formal reading, standing mute to all charges, court will enter a not guilty plea. Pretrial in these matters will be set
January 20th, 1:30 before Judge Conte.
January 20th, 2026, 1:30 before Judge Conte.
Yeah.
Bond in all of these matters will continue.
Thank you, Your Honor.
Thank you, Your
Thank
Honor.
you. Thank you, sir, and
I
good luck to
appreciate
you. All right. No, I did. I don't know what it is here. I know he does, but he called it first, didn't he? Court recalls case, People versus Bobby Tennyson.
David I. Goldstein appearing on behalf of the defendant. Your Honor, may Mr. Cook and I approach briefly?
Briefly.
Quick approach, kills the mics for that. We do have a couple other courts that are in action, but not sure. Some of them are civil and debt collection stuff.
He's just got a bad word.
I recognize there was a previous competency situation there. So do you want to plead guilty, sir? You keep looking at your attorney like you don't know. What do you want to do? What do you want to do?
I want to go.
I want to go. Can I be let go, Judge?
Plead guilty to what? No, look at me and talk to me.
Yeah. So I just froze my hand.
I know. What do you want to plead guilty to?
My rights.
You want to plead guilty to your rights?
Yeah. I want to go what it says in the paper.
Yeah. What does this say in the paper?
That what he wrote down and gave to you.
He didn't write anything down and give to me. There's an advice of rights. These are just the rights that you have.
Right. I went over my rights.
Okay, so you understand that you have the right to be considered innocent?
You might not be able to hear.
And that they would have to prove you guilty?
Yeah.
And that you have the right to question any witness that they called to testify against you?
Yeah.
And you understand that you have the right that you could call witnesses that could testify on your behalf?
Yeah.
You could remain silent at trial and they can't use it against you. Or you could take the stand and waive your right to silence and testify to your own defense. You understand that?
Yeah.
And you want to give up all of those rights?
No.
No, he says.
I don't know that he understands, so I can't.
I'm a little concerned as well.
Yeah, I think it's a competency issue.
Competency for sure.
We sent him for competency. They determined he was competent. The order was signed, I think, December 10th. We could reapply, resubmit. I don't know.
I get, and was he ordered to be on medication once he was released?
Yes, he is.
Has he been compliant with his medications?
Yes.
Okay. Yeah, there's still an understanding issue, so I'm not able to take a plea at this time. So I'll let you further counsel, and if you want to resubmit for competency, I'm happy to sign it. Is there any objection from the?
None, Your Honor.
Thank you. You're all set for today, sir.
Thank you, Your Honor.
Yeah. Who are we standing for? I guess the judge left. That's why. Let's go back to Simpson.
That he is going to be pleading guilty to the charge of attempted resisting and obstructing the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement. The sentencing judge waiver is not checked, but that was reviewed with him.
Oh, I'm sorry. You understand you wouldn't be sentenced in front of Judge Simpson?
Yes, yes.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
State your name, please.
Jermaine Johnson.
All right. Sir, it is this court's understanding that you are going to be, hold on a second. Yeah, there's two cases, and I'm sorry, I didn't go through the other one. In the other matter, that being the case ending in 5805, he's going to be pleading to use of cocaine. That's a count 3, and counts 1 and 2 would be dismissed. And the sentencing judge waiver would also apply to that one. You understand that, sir?
Yes, yes, I do.
Yes, Christian. All right. been sworn. Sir, I do, on the one case, court believes you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
I understand, yes.
And on the other matter that you're going to plead to the charge of use of cocaine, that's also a misdemeanor punishable by up to 1 year, $1,000 fine plus court costs. You understand that?
Yes, I do.
All right. You understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentencing these matters before Judge Valvo, or her successor, which we kind of know now, but I'm not sure the documents will stay that way.
Can't say her name yet.
You understand that, sir?
Yes, sir.
All right.
His name. Allison Garofolo, 17 months officially, but a lot longer.
Understanding that, you still wish to plead guilty to these charges?
Makes you an OG.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of use of cocaine, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
I understand.
You signed or had cause to be signed an advice of rights form on your behalf. Is that correct? You have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
I understand, yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Voluntarily.
Of your own free will?
Sir.
And because you believe that you're guilty of this?
Yes.
Yeah. On the date, starting with the attempted resisting and obstructing, on the date of November 24, 2025, at the location of Las Vegas Drive near Palomar Drive in the city of Ann Arbor, Washington County, state of Michigan. Did you come into contact with police officers from the Ann Arbor Police Department?
Yes, sir.
What happened?
I rode off on my bike.
You what?
Rode off, tried to get away.
Did they give you an order to stop?
Oh, they told me to stop.
They told you to stop.
And you didn't.
You said, I'm not stopping, and just kept going.
I was thinking about Thanksgiving.
You were thinking about what?
I was trying to make it to Thanksgiving. I promise.
It's all about the turkey.
Was it 20? What was it, 24? Trying to make it to.
So 3 days before you were trying to make it to things, where were you going?
I was trying to make it home.
Okay.
Get myself in.
I just didn't want to be in custody over Thanksgiving.
I see what you're saying. That didn't work out, did it?
No, it didn't.
Yeah, it didn't. Okay. And you knew that they had given you a lawful command at that point, and you disobeyed it.
Yes.
All right. The other case. These would be uniform, there wouldn't be a problem. I'm not gonna worry about it, we'll just find it in here. Seriously, people. On the date of June 4, 2025, at the Packard Road near Platte Road, city of Ann Arbor, Washington County, state of Michigan, did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right. Sir, I do have to advise you that if I accept your plea, between the time that I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not, first of all, not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of guilty in each of these cases to count 3. Counts 1 and 2, I think the vote matters, are dismissed. Precepts investigation and report is ordered at 15th District Court. Probation sentencing will be
Third at 9 a.m.
February 3rd, 2026, 9 a.m. And it's before Judge Valvo in each of these cases. On will continue. He has I did, so that you're aware, I don't know if it was sent to you, their they requested that he be released to treatment. I approved that on his cases. So he might go to treatment. That was something through the sheriff's department that they sent us.
Would Your Honor consider, in light of the plea, a personal bond today and then allowing him to, of his own volition, seek treatment?
You really want to go back to the warrants where we had to find him?
Oh, you're not gonna have to find me.
Well,
we did.
We do have his current address. We know where he would be located.
I should have just let it go. What I was trying to tell you is I've signed an order to release to treatment.
Oh, yeah, that's fine too.
And that was sent through the jail process as opposed to, and I
found a new Kentucky court
treatment. If you'd like him released on a PR bond, you can take that up with Judge Calvo's successor or whoever's handling it. I'm not going to change it at this point.
I understand.
All right. Thank you.
We're going to jump to Kentucky.
Good luck to you.
Is that correct? That is correct. Okay. And you had no other information other than what this informant told you that this vehicle had been to the Canatcha residence. Is that correct? I believe that is correct. Yes. Okay.
It's another Zoom court, but it's taking evidence. Don't know what's going on. It just seemed a little
Now,
heated when I saw it. Was it built yesterday?
Your affidavit states that you received information to traffic stop. First of all, the traffic stop, you had a search and found a plastic bag of white powder substance. The substance field tested positive for methamphetamine. That's correct, right? That's correct. Okay. Now, below that in your affidavit, it says acting on the information received. Now, I'm not understanding how this information, what information was received by you before we get into this so-called independent investigation. Can I refer to mine? Yes, you may, sir.
What information did you receive? Where did it come from? Tell
Right
us
here,
about this information.
on this page. Yes, I have it. That's what I have pulled up. But I'm not wanting to get into the second part. I'm wanting to get into the part above that. What information was received other than you found meth on this informant?
That they had previously left the residence of 656
But
Cat.
that says,
Well, I didn't finish his answer.
I'm sorry, please finish your answer.
Sir. And that arrestee, while it was at the residence, used methamphetamine. That was the information that we were
Okay,
talking.
so what you're stating to this court is that was the so-called following independent investigation, correct?
Be correct.
Okay. But what happened? I'm trying to figure this out. You stopped this individual and found meth, correct?
I did not stop the individual.
Okay, so you were with some people that did.
Yes, sir.
Methamphetamine was found, correct?
That's correct.
At that point in time, there was information either volunteered or responded to by questioning that I got this meth at 656 Cat and Mouse Road or Shirley Canatchers, whatever. Is that correct?
That's correct.
Okay. Now, after you received that information, what independent investigation did you do?
We acted on that information.
Okay, so am I correct? And there was no independent investigation by you, or as far as you know, by any of these officers after this after this informant told you this information, correct?
There was questioning to the informant for validity,
but that's all at the time.
Let him answer his question.
that substances would be there. We then took that information to the county attorney, then a search warrant was.
But what I'm asking is, after you got this information from her that said she'd been to a house 2 miles, what other independent investigation was conducted, if any?
That is all.
Okay. And the only dealings that you had with this individual before is prior arrests, correct?
Correct.
Would that affect your determination as to the credibility of an informant if you'd arrested them before?
No, sir, I believe that they were telling me the truth at the time.
You believe they were telling you the truth, but no methamphetamine was found, was it?
That's correct.
Okay. I have no further questions.
Actually, according to your affidavit that you read just a moment ago, the arrestee in that instance said that she snorted a line of dope and took 2 hits of meth. Is that correct?
That's correct.
Right. Now, was the address that the arrestee gave you the address of Mrs. Coniston?
Yes, sir.
And you all went, after you went to, where did you get the search warrant?
The county attorney's office.
Let me ask a question here. How long did the person you arrested say it had been since they had been to this residence that you ultimately searched?
Sir, we were told that it was directly like previous to the stop.
How long after you got the search warrant did it take you to go to the address that was given?
Approximately 30 minutes.
This is
Same night.
From the signing, yes, sir. The signing of the search warrant.
And exactly what did your
I need to
return
grab some water, guys.
show
Hang
that
on.
you found there that night?
Can I refer to my?
Yeah.
There's approximately $9,058 in cash. That was in multiple denominations and bags and some bills laying loose.
Where was that located?
This was all, this part was all found in a safe, in a bedroom to the left of the house. It was, believed to be Shirley Canancer's bedroom. Also, she stated to us, that was her bedroom.
When you say she stated that it was her bedroom?
Miss Canancer, Shirley Canancer.
Is
stated
the
to
lady
us.
sitting here?
Yes, sir.
What else, if anything, what else was found?
There was 51 dosage units of a white oblong pill with the inscription M523. It was in a clear plastic bag. That came back to be oxys, 10 milligrams. There was 50 dosage units of a yellow round pill with the inscription 230. It was in a clear plastic bag. That was also oxy, 10 milligrams. There were 6 clear bags containing suspected marijuana that had a total approximate amount of 25.65 grams. There was also 9 pill bottles containing different types of legend drugs. The majority of it was tizanidine.
Did you find anything else related to drug activity?
Not in that room, sir. That was all.
In the return, I'm looking at Mr. Cross. Do you have the return or a copy of the return in your records?
I don't think so, sir.
Do you know who prepared the return?
That was me. That was
all right. So when I ask you if there's anything else other than the pills that you described, okay. Did you find any drug paraphernalia?
There were, various pops, and then there were 2 digital scales.
You found digital scale?
Yes, sir.
I have a digital scale, but it's for mailing things.
Sure, he's the one that got that really detailed.
You're picking up on the microphone. You're picking up on the.
All of this witness stuff.
Okay, you have anything else?
Now, Deputy Pendergrass, the return says, quote, various drug paraphernalia, close quote. Did you itemize or particularize what you said were pipes found?
There were just multiple pipes that were collected. That was all.
And when you say pipes, what kind of pipes do you mean, sir?
Pipes used to smoke substances.
Were these in the safe? Were these found in the safe?
No, that was not in the safe.
Okay. You know who was living at the Canatzer residence?
Shirley Canancer, Tawny Canancer was there. There was also a juvenile, male. And also they had said that, I believe it was a grandson, was also staying there, but he was not present at the time for the search warrant.
Now, the safe was locked, correct?
Yes, sir.
Okay. Now, let's go back to the initial traffic stop regarding the informant. The informant didn't say 656 Cat and Mouse Road, did they?
That's correct.
What did they say? What did they refer to?
Cat and Mouse?
Shirley Canancer's house.
Okay. And did they specifically refer to Shirley Canatzer or just say Shirley Canatzer's house?
They said Shirley Canancer's house, and when I further questioned them about where, they said it was on Cat and Mouse Road. They were able to describe the house.
I love this
which
road.
side of the road it was on.
Now, when you and the other officers obtained this information, did you all have a discussion amongst yourselves how next to proceed?
Yes, sir.
Okay.
It was a mutual.
But what was the nature and substance of that conversation, sir?
Well, I can't exactly recall. It's been almost
Now,
a
Officer
year.
Pendergrass, you're not a native of Clinton County, are you?
No, sir.
And I believe you live in Tennessee now, correct?
Still live in Kentucky.
Okay, okay. How long have you lived in Clinton?
Approximately 5 years.
Okay. But you didn't have any experience with this informant other than being involved in arrests prior to this night. Is that correct?
That's correct.
Did you discuss with Hickman, Poole, Markham, any of the other fellows of their prior experience or dealings with this informant?
I can't exactly recall if I did or not.
So based on what you can recall today, no one in that group indicated they had previous, no one, rephrase that. No one had any basis for believing that this individual was reliable based on any prior dealings with it. Is that correct?
I can't recall the conversations that we had.
So you can't remember anybody saying, oh, I believe her, she's told me stuff before or anything like that? No conversation regarding that?
I can't recall, and I would,
Okay.
I wouldn't want to say I did, and it's been so long, I can't recall the conversations that we had.
You know, you can't recall.
It wasn't
Thank you.
citation.
That's all I had.
In the conversations that you had following the arrest on a traffic violation, Mr. Cross asked you about conversations that you might have had with Sheriff Markham and who is it, Officer Hickman?
Sheriff Markham wasn't involved.
Who else was there?
Well, I know who was there. You know, there's a state trooper, city police officer.
Officer Poole. Did anybody indicate to you that they recognize that address to be in a high drug traffic area?
Yes, sir, we all knew that that was a high drug trafficking area.
So there was some investigation made other than just relying on what the individual told you.
Yes. Just prior knowledge, of knowing of that area.
That it was a high traffic
Yes.
area.
Yes, sir.
Great.
But the affidavit says you conducted, quote, following independent investigation, close quote. And you just simply had some knowledge, some reports from somewhere that there may have been some drugs at the Canatzer residence, correct?
Yes.
Okay. You didn't conduct any subsequent investigation.
That's
correct?
already been asked and answered multiple times.
I understand.
Okay, thank you very much. You want to make your argument, Mr.
Your Honor, I'm through with Deputy Pendergrass. I do want to address the court regarding the name of the informant.
I'm not going to give you a name.
Your Honor, I understand that at this point in time, but I wanted to address the court and move to do something. I would move.
Your motion.
Yeah. I would move that the name be furnished to the court in camera and divulged to counsel for the defendant so I can make my own investigation of this individual and the prior criminal charges that they've had in order to help gauge and determine the reliability. The basis of this is we've heard that he's had prior dealings with her, but nobody had any informants. I just want to see what kind of record this gal's got, if it's a female. And I think that's appropriate. It's a safe way to do it.
Okay, Mr. Henley, you want to make your argument on
This is already has my phone.
As I understand the privilege law in Kentucky, it starts out that at the initial stages, they definitely is a privilege. The Commonwealth does not have to reveal the name.
I've already ruled on that. Okay. I
wasn't
want
aware.
to know about the validity of this
court is so laid back.
search here. I want your ultimate argument. If you can give the argument.
Well, I think the search judge is valid. You've heard the proof.
Tell me why you think it is.
Well, there's no reason to suspect that informant was telling anything but the truth. That's not.
Well, let me do a Socratic method here. Okay. What, you got something?
No,
Okay, so what we have here is we have a stop of someone who is arrested.
That's correct.
They're charged. On interrogation of the individual, they say that in an approximate time, they've been to the defendant's house and used drugs there and bought drugs.
That's correct.
Okay. Now, and so they come get a search warrant, they go there and they find drugs there.
That's correct.
And then she makes a statement.
Let me show you a little picture Josh gave me
She
here.
knows who it is, which would indicate to me that maybe there'd been another transaction.
That's possible.
Going on there. That's possible. And then they search and they find drug paraphernalia and they find drugs, multiple units of various drugs, and that's right.
This is what they found.
Tell me why that search is valid, or is that enough? Did they have to do any other prior investigation or reliability?
Well, you left out the most important thing, I think, Your Honor, is that all the officers there that night when the girl gave them the address recognized that to be a high traffic drug area. And
okay, now with that additional information, is that enough to sustain the search?
I think it very well could be.
Well, I know I'm going to decide what it could be. I want to know whether the Commonwealth believes it is.
I don't see why it wouldn't be.
I want you to tell me, and you think the case law in Kentucky allows the search under the circumstances that were just related by you and something that.
Well, the case law is all over the place on these things. Depends on which case you would pick out. But
Here's the thing. You're going to have to tell me what you're relying on.
You want us to brief the case?
I'm going to ask Mr. Cross. You've heard what the Commonwealth had to say, and I don't believe it's necessary for you to respond to this juncture. And I'll let's have the case brief, and we all agree on what the facts were. I stated the facts, and you supplemented with something that was crucial. So we will have briefs on the thing.
30 days, okay, Your Honor?
30 days is fine.
Thank you.
This officer be excused. You may be excused. Okay, thank you. We'll schedule this case to come back on February the 12th. February the 12th. Billy Davis Jr.
You got to love
Billy
this name.
Davis Jr.
Billy Davis Jr.
Commonwealth versus Billy Davis Jr., 25 CR 0071. You are Billy Davis Jr.
Yes, sir.
Good morning. Were you born in 1970?
Yes, sir.
That's 4 days of Social Security number 1. Here today for sentencing. Had you have an opportunity to look at the pre-sentence investigation report on probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counsel, is there any reason that this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty possession, upon plea of guilty, with failure to maintain insurance required by KRS temperature of 40, you should pay a fine of $500. Thank you so much. And costs or plea of guilty possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence 3 years probation for 5 years. For any clinician, follow recommendation. She received critical time served and shall obtain gainful employment. All evidence is to be destroyed by agreement.
All evidence to be
Okay,
destroyed
now
by
what is the
agreement.
total court cost? And then you got the $500 fine.
Ooh. Inmates in the background.
$5, you need some time to pay it. Yeah, I allow you to pay it $60 a month. Okay, the first payment is due by 30 days from today. You'll need to meet with the probation and parole officer. Probation and parole ready to meet with him? Okay, thank you very much.
Have to fix the hair.
Erica Decker.
Unfortunately, Tennessee, Kentucky, West Virginia, and many other states are having a major fight with some pretty hard drugs. Meth is destroying entire communities.
Are you Erica Decker?
Yes, sir.
You born in 1994?
Yes, sir.
Last 4 digits, your social security number 9. You're here on the pretrial conference in 25 CRs 0000103. Correct? Okay. What does the Commonwealth have?
We have a diversion plea.
What does the Commonwealth have? Let me fix this audio just a tiny bit.
And we'll, after we finish this case, we'll immediately go to the 404B hearing in Stocking case, just to give the Commonwealth. That's a motion been tendered, ma'am, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea voluntary given?
Yes, sir.
Are you the same person that we identified a few seconds ago in 25 CR 00103?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed these matters with your attorney? Are you satisfied with his advice?
Yes, sir.
When you review the evidence the Commonwealth has against you, you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a plea in this case. You have certain rights under the Kentucky United States Constitution before I can accept a plea.
Yes, sir.
I need to know that you understand that. I'm going to go down through them. If you have anything you'll ask your attorney, you step away and ask him. Okay, you have a right not to testify against yourself.
This is a bit of a mumble court.
Right to speak trial, but you have to be represented by counsel to the trial. Right to confirm possibly not witness call testify against you. Right to be evidence. Right to call witnesses in your favor. The right to appeal this matter to high court if you lose. The right to apply the Commonwealth prove on a reasonable doubt that you're guilty of the charge against you. Understand that by entering a guilty plea today, you give up all those rights.
Yes, sir.
Consider the Commonwealth's recommendation, but I may also apply any range of central law. I don't have to accept your recommendation. In the event that I do not accept the recommendation, I will decide to impose a harsher punishment. Now, I want to ask you some questions to see if you're eligible for pretrial diversion. Have you previously been diverted in the last 5 years?
No, sir.
Do you have any felonies in the past 10 years?
No,
Are
sir.
you currently on probation?
No, sir.
You understand that if you successfully complete the diversion agreement, the charges will be dismissed, pretrial diverted, you can have your record expunged.
Yes, sir.
But if you do not successfully complete the diversion program, you'll be brought back to this court. I can decide to set aside the diversion and schedule a sentencing hearing. And you be a convicted felon. Do you understand that?
Yes, sir.
Ms. Gordon Anderson, are you presenting the
Okay, we're going to
recommendation
jump back to
of the
Simpson. I've never seen this camera angle.
I don't even know.
Upon plea of
Here's the
guilty to
problem.
possession of controlled
And I don't
substance,
have a
first
problem with
degree
that, Mr. Gilliland.
methamphetamine, the
The
defendant shall
problem that I
receive a
have
sentence
is
of 3
something's coming back from circuit court. It's supposedly set for the 15th. I don't know that. And usually, if something is going to be set on this docket, we get a call. If somebody tells us, because we'll give them the date. And so what I'm a little bit worried about is I'm going to adjourn this young man's case out next week, and I still don't have that other case.
I think I can't say for sure, but it sounds to me like the circuit court case, circuit court.
I don't know why that's coming back to us. I don't get that. And I'm not saying that anything you're telling me is not what you know. I don't know why it's coming back, and I don't you're telling me there's this case coming back. He's got this case. I remember what I did when I released him on the other case. And now he's back in, and you want me to give a date that I don't know is going to be able to go for. I mean, none of this is making much sense to me.
I think this young man thought that there would be no new charges.
Well, whether or not there are new charges or not, I don't know that is necessarily my issue right now. My issue right now is I'm trying to get his case heard. And I can't, this case that's in front of me right now, I can't even get that heard because now you're telling me there's this other mythical case coming back to, I don't know. And it's on the same date. Do we have anything?
1 week. No. You don't understand what I'm saying.
No. Here's the thing. If I adjourn it out, well, you guys have your conversation. I'll just wait.
Judge, I'm sorry. I understand his frustration, but I don't have.
Well, yeah, I understand his frustration too, because he waived up. I reduced his bond. New charges come. He then gets he then can't go. And then when the case goes up, regardless of what his understanding was and what that was, now all of a sudden it's going to come back. Meanwhile, while all that's happening, I'm in custody. So, gee, I don't know why he's frustrated. Because as you can tell, I'm not.
I think it's time for a break, Judge.
Okay, but here's what I'm going to do, okay? You may not like the answer that I get, but at least what I'm going to do is I'm going to get an answer so we know what to do, okay? Because I don't want to set it for next week, and next thing I know, that case coming from circuit is 2 weeks out, because then I got to bring him back again. That doesn't even make any sense to me. So say nothing.
Judge,
say nothing.
As far as bond,
say nothing.
You're very considerate, Judge. Judge, I think. Would you?
What?
Huh?
What's the probable cause for this case?
Fine.
Please ask that.
Here's what I'm going to do. I'm going to pass the matter, take him back. I'm going to call down, or have my staff call down. We're going to figure out where this man's case is at, where everything is, and try to get it all where it's supposed to be.
All right, thank you.
And nobody may like the decision I make in the end, but at least we'll know what's happening. Because right now, we don't even know what's happening. You understand me?
Yeah.
Say nothing. Take him back.
Wow. You need a break, Judge? Mr. Wesley is about to make an appearance from his jail cell.
Court calls the case, People versus Donovan Smith.
Donovan, is that you?
No, that was the same case. Why are you doing it? Just.
That was the same case.
Is this the one? It is. Court calls the case, People versus Wesley Brand.
Here's
Why'd
Wesley.
you take those other ones?
And Maggie, on behalf of Mr. Brand.
Mr. Brand, can you state your name for me?
Wesley Brand.
Thank you.
Food hole.
You're requesting an adjournment.
I am, Your Honor.
You got to get the discovery. Probable cause conference will be adjourned to January 22nd, 2026, 9 a.m. Bond continue.
He's not happy.
Court calls case People versus Mark Copeland.
Anna Mackey on behalf of Mr. Copeland. Who is, Mr. Copeland?
What are you doing to Lebo look? Are they here or not?
In the hallway?
You know what the Lebo look is?
Pardon?
You know what the Lebo look is?
The what look?
Lebo look.
No.
Debo gets up here all the time. I call the case. He doesn't know if his client's here, but he looks at the door expecting some miracle. So I expect that's what you're doing.
How did I get involved?
You're the cause of it.
I tried to get a hold of Mr. Copeland. His phone number was invalid and his email was also invalid. We're respectfully requesting to adjourn this matter so I could attempt to get a hold of him.
Bench warrant will issue bond 10,000, cash surety. That warrant will issue immediately.
Thank you.
Court calls the case People versus Latricia Mopkin.
Hannah Mackey on behalf of Mrs. Mopkin, who's approaching.
No, look this way, ma'am. Come on up. Your name?
Latricia Mopkin.
Thank you.
Your Honor, requesting to set this matter for preliminary examination. And all discovery is complete as far as we are aware.
Will the people have their witnesses available the 20th? Preliminary examination in person will be set January 20th, 2026, 9 a.m. before Judge Fresh Hour.
May I address bond, Your Honor?
You may.
Ms. Latricia, she works at U of M as a housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids and one of them, Ms. Latricia is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
Responsible.
Your Honor, at this point, I'm going to object. This is an extremely serious case in which the victim was attacked with a hammer in which she was hit in the head several times with that hammer.
What?
There was a struggle then for that hammer, and during that struggle, he was then stabbed in his stomach. So given the severity of this case and the injuries that she sustained, I'm going to object at this point to any modification of bond.
And Your Honor, we are presenting this case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
I mean, typically the self-defense isn't, I mean, are you indicating that the alleged victim possessed some weapon at some point?
I believe there was some form of altercation.
Well, an altercation is one thing. Are you saying that a weapon was possessed? Because that might factor into the court's decision, but if that's not what's being said, then I'm not sure that true self-defense is going to apply in any event, although I'm not trying to make that analysis.
There was no actual weapon.
Dontrell is frustrated, the inmate in custody right there. He was banging on the window, yelling something. Now he's pacing around his cell. Stabbed and hit with a hammer is not an altercation. Yeah, that's pretty serious.
Do this. There's the allegation that there are 2 weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay, then you can certainly address that even while I'll factor that in. I still don't think bond would be appropriate, or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the preliminary examination on the 20th before Judge Fresh Hour.
Yeah,
Thank you, Your Honor.
Thank you.
Just trying to address bond, attempted murder. Good luck.
This defendant is in Zoom.
Defendant's on Zoom. Is it Kusia?
Looks good. Guys want to walk around? Young lady? No, come here.
Uh-oh.
Come here.
It's about to
boy.
go down.
Get her, Mr. Allen.
Get her. Run. Run.
Who is that?
We've got some action in court. Did she get out of the building?
Who was that?
Family of the last client, I believe, Your Honor.
Family of the last client.
To the full moon.
What?
To the full moon.
Is it a full moon?
No. People are usually better. They're not back yet. There's a problem.
I think
you got a problem probably in the hallway, guys. I'm sure security sees it. Can you just call and make sure that they're...
We've got security filing out, as well as some people. See what's going on. If I hear "Don't tase me, bro," in the hallway, we'll know. Coming back in.
557. And you got that over there.
Be careful.
I wonder if there's been a takedown and now medical's required.
Should have given bond. Yes, I'm so sorry. Yes. So that matter has come back.
This is a lot of drama for Judge Simpson.
Yes, but yesterday, the company's office called. They don't know. On next week. So.
Just step off. If she brings them in, just throw her in the box over here or cuff her, put her wherever.
Cuff her. Now we can't go. Judge is taking a break. He's trying to look.
Lady, what's your name?
Sequoia Jones.
What?
Sequoia Jones.
Why were you causing a disruption in the court and then
I
didn't
was
come
talking
back?
to my mom's lawyer, and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
I apologize.
That doesn't work that way.
Your Honor,
You want to be represented by counsel, ma'am, because you disrupted these entire proceedings. You want an attorney?
Yeah.
The PD can handle this, I think. She can go back into custody. I'm going to take a brief recess and then I'll bring her back out. We'll deal with it.
All right.
It always sucks when the judge is a witness in your trial. That's basically what we have now. Judge's going to take a couple-minute break here and cool down. Probably get to the bottom. I imagine we're probably going to see some compassion here. She's already apologized, so I don't think the judge is really going to crack down. But he is going to let her sit for a little bit. But when you're in court and the judge observes you doing something that's bad, and he says, "Hey, stop it! Come back up here," and then you run from him. He has all the evidence he needs. He can hold you in contempt. She might need to sit this one out for a little bit. Let's see if we can watch the replay really quickly, see what happened here. Let me grab that here. Import media. Checking the replay. Don't think we heard the audio very well, but all right, let's rewind just a teensy bit. Okay, I'm looking for her. Mr. Allen's still in the courtroom here, so he hasn't left yet. Oh, there he goes. Okay. Hang on, let me get... I think it's about right here. Give me a second. Let me see if you guys able to see. Oh, you're still looking at me, and now you're looking at drugs. You don't need the drugs. Hang on. We'll get rid of the drugs real quickly. Not my drugs, by the way. These are a picture from court. Let's get rid of that. And now let's go over here and bring up a clean feed. Workspace. Give me a clean feed on Blackmagic. Boom. All right, let's play this really quickly and see what happened. Do we have audio on 3? Yes.
Guys want to walk around?
Judge is looking at something.
Young lady? No, come here.
Okay, stop. We're going to rewind just a tiny bit. See if I can zoom in just on this block up here in the top, right? Where's my sidebar of tools? The mixer. I'm on the wrong machine here. There we go. Okay. All right, let's do a wee bit of a zoom in. We're going to watch this top window here because that's where it all occurs in. So let's get that over. And then bring it down just a tiny bit. A little more zoom out. There we go. Here we go. Okay. This is the one we're going to watch. Let's watch this again.
Walk around.
Young lady? No, come here. Come here. Oh, boy. Get her, Mr. Allen.
It's not a lot, but the moments that there was a problem, you can see Mr. Attorney here in the gray suit, right? I think he was the one that the conversation was occurring with, so the prosecutor. There goes Mr. Allen.
Looks good. Guys want to walk around?
Okay, so right here, the gray suit's turned around talking to the mom. Or no, that's the daughter. Yeah, that was it.
Young lady? Yeah. No, come here. Come here.
Come here.
Oh, boy.
Oh,
Get her, Mr. Allen.
Get her. Get her. Okay, so that's all that happened there. That's the replay. I should have run it on the other machine where I could have used the rewinder, but I did not want to mess with Mr. Allen. A lot of people actually have expressed a personal desire to be handcuffed by Mr. Allen. So little does she know, she's living out the dream. But yeah. Mr. Allen wasn't able to stretch before the pouncing. No, he was a little bit slow on the uptake, but he did start moving before the judge even really acknowledged there was a problem. He started walking forward. I volunteer as tribute. Yeah, a couple of you said that. I'd volunteer for that. Y'all are going to get timed out by Red or one of the other mods. Here come the comments. Yeah, I'm sorry. I shouldn't have started that. Apologize, mods. All right. Let me shut that down just a little bit. But now we can't really go anywhere because we want to see how this one ends. But the judge has been known to take long breaks before. It is 11:27. The only thing that indicates he might be back quickly is he just needs to cool off, possibly watch the video to see what happened, and then come back and talk to the person who is now sitting in the hot box in cuffs, has to answer a few questions. Obviously, family can be a little bit agitated as court proceedings don't go the way they hope. And she had some issues with the prosecutor. So, young lady stopped there. Is the girl refusing to come back in? She did refuse, and she walked out. And the judge sent Mr. Allen and everybody else on the posse after her. She was stopped out in the lobby. Took a while to get her back in. Simpson loves long breaks. Yeah, but he's still in the middle of his docket. This is not the end of the docket. He doesn't want to be behind for the rest of the day. He knows that. So, court's busy. There's a lot of people still sitting there in the courtroom waiting. Mr. Allen makes me want to go to the gym, like a New Year's resolution, not to work out, but to watch him work out. Okay, I see this. Why aren't we seeing what is happening? Because they're on break. We don't get to see when they're on break. The judge is not there. When the judge comes back, he'll turn his camera back on, and then we'll see what happens. Judge Simpson would have just talked to her about saying that out loud. I think he has an issue when he told her to come back and she ignored him. Right. That's the issue. Maybe there'll be a fine involved. He can issue a fine for that. But Josh says, I can issue fines too. Payable in time. Outs. Save the sound clip. Come here. Is it clean? Oh, there's a lot of noise in the courtroom, right? Then Alan charged after her. Yeah. Did take a while to get her back in. I didn't hear taser, taser, taser. And no medics were called that I saw. So imagine she was just agitated. Okay, we can watch another court, but we'll have to keep this one in the viewfinder. We can't get rid of Judge Simpson altogether. Not going back to Kentucky, Mumble Court was no good. Travis County, Texas is live, but they've been doing some civil debt collection type stuff, which is not my favorite. Let's see. Judge Hunter. Where's Judge Hunter? Let's pop this one up just for a minute. Hang on.
All right, I asked that only because I want to make sure that I have the prosecutor prepare a writ. Can you prepare that writ, Mr. Rolla?
Taking notes of that, thank you.
And Mr. Rolla, anything further today?
I've got the audio from Simpson live, so we'll hear it and we'll jump to it as soon as it goes live.
Your Honor,
He's gotta
to the
make some choices.
extent that there's Mr. Aldridge, did you post your bond in this case?
I did.
To the extent there's any bond?
Are you asking that he canceled?
Yes.
And is Mr. Aldridge, I'll ask you, Mr. Truish, is Mr. Aldridge already serving a sentence in Antrim County?
I don't know, but frankly, I don't think there's no scenario where it would ever harm him to have it canceled.
So why don't you just submit an order that bond is canceled, have it signed by the prosecutor just as to the relief granted, and then I'll sign it immediately upon receipt. Mr. Rolla, do you have any objection to the bond being canceled?
I do not, Judge, and he's serving time based on information received in Antrim County on their charges.
All right. Well, Mr. Aldridge, we'll bring you here for the in-person sentencing in about a month, and we will see you then. Thank you.
Thank you. I got a question.
Go ahead.
So this is what I was trying to ask about earlier. So will my time here be ran concurrent with over there?
So the question is more complicated than a straight yes or no, and the reason is the prosecutor just suggested he believed that you were serving a sentence right now in Antrim County. If you're serving a sentence in Antrim County, you can't get credit for any other case if you're serving that sentence. So while the cases might run concurrent in the sense that you won't be serving it consecutive to Antrim County, it's also true that you may not be earning jail credit right now if you're actually serving a sentence in Antrim County. So if you've already been sentenced in Antrim County, you can't get credit towards any other county. You're only serving the sentence in Antrim County under Michigan law.
So I'd have to serve my year here and then go there and serve time there too.
Well, again, the question is not that easy because even if you're sentenced to time in this county, it may be that I order your sentence concurrent to your Antrim County case, but it might also be that you can't get credit for the time you've been sitting in the jail there in Antrim. So the question of concurrent versus consecutive sentencing hasn't been answered yet. But at the time of sentencing, I'll go over that, and the recommendation will be in the PSI, and your attorney can go over that with you as well. Okay. Mr. Church, did you wish to offer any other information?
Just Mr. Aldridge, I'll set a call up where we can go over. It is sort of a complicated process, but we'll talk through what that looks like.
All right. Thank you for trying to answer my question.
We tried.
You're welcome. Thank you.
I'm not a big fan of face tattoos as personally, but it always strikes me as odd that someone who seems to be living a life of crime or frequents the court system would mark themselves in a way that would make them very easy to identify in case a witness had to, pick them out of a lineup, right? It just seems like if you want to get away with something, maybe blend in more. Where and what do you recommend? Greeners, that lower back tattoo you have of Adam, I think that's tasteful. I think that's perfect. Yeah, I saw it. You mentioned that a couple. I think you were the one who said it, Greeners. It started as the burner phone number, morphed into Adam, then became emoji recaps. Your fallback is an emoji recap. Oh, man. Tasteful and elegant, of course. Tattoo removal. Obviously, there are some people who have just amazing artwork that's done in tattoos. I don't have any myself, mostly because I'm scared to death, and I'm terrible at making decisions, right? Mods can tell you this. I'm terrible at deciding, and I frequently will put off making decisions and then regret the one I took. Imagine if Josh said, "Hey, I think this court might be a good one. It seems to be a great court," and we all went out and got like that court image tattooed on us, and then it turns out to be not a good one, right? I would have regret. I would have regret. Now, I trust Josh enough that I'm okay with watching whatever he suggests because most of the time it's really good. But I don't trust my own decision-making skills. And I like rainbow trout. I want one on my bicep because, turns out that, I'm getting older and as body's change and stuff, that rainbow trout might turn into a carp, and, or a pot-belly goldfish, as the case may be. So, no regrets. Maybe what ruined tattoos for me was my friend growing up in high school got a tattoo, and he had his friend, who was actually somebody I put in prison, do it. So they made their own tattoo gun using like a motor from a cassette player, and it was like as sketchy as you could possibly. They used like a Bic pen ink. It was awful, and he loved music. He loved rock music and some pretty hard stuff. And so he thought, I'm going to get the logo from my favorite band tattooed on my arm. And he did it backwards. He messed it up. But once it's on, you can't fix it. I have heard they are addictive. That once you get some tattoos, it's like, okay, now I see the deal. But yeah, no, the guy who did the tattoo did it backwards, and it looked right in the mirror, so he didn't catch it because he couldn't see it because it was on his arm, so he would always look in the mirror. And the band name was 9 Inch Nails, N-I-N, and the N's were both flipped from the way the band has them in their logo. So. All right, no regrets. I'm not down on anybody who chooses to get a tattoo. I've seen many tattoos that I've just been really impressed with. I thought the quality of the artwork is just amazing, and I can definitely understand why somebody would want that canvas that they carry around with them. I just think that if you want to live a life of crime, so it looked like the Kia logo. Basically, he was just before Kia actually changed their logo to look like it does now. If you want to live a life of crime and being picked out of a lineup is a regular occurrence for you, perhaps you want to blend in more. All right, 9 Inch Nails, worth it, worth it. Love 9 Inch Nails, went to their concert last. Are they still touring, Emmy? Wow. There are very few concerts that I'd want to go to right now, mostly because my ears ring naturally by themselves, and after a concert, they just ring more. Preserving what little hearing I have left. And I could do a Dave Matthews Band. Emily and I could hook up on a road trip as far as, meet in Red Rocks, and sit in the VIP seats and watch Dave Matthews. I'd love that. I'd love that. And it's a bucket list band for me. My buddies went to Metallica when I was a kid. They went to a Metallica concert. I think it was in Park City, where we just were in court yesterday. And apparently they were so stoned that they couldn't play their songs very well. That's the rumor. That they struggled. They struggled to do the concert. I would think you'd love Bare Naked Ladies. It's a good band. It's a good band. I like them, the Killers. Obviously Dave Matthews. Trent Reznor helped develop Apple Music. Oh, really? Sounds like Guns N' Roses, not Metallica. Last concert was Korn. You guys listen to some hard stuff. I wasn't sure you guys would get the 9 Inch Nails reference, but wow. Korn and Rage Against the Machine. It's like in Breaking Bad, the neighbor tattoo artist had done. She said she had commitment issues. Breaking Benjamin coming to the UK in July. First time since 2017. Looking forward to it. That looks cool. Is that going to be in Wembley? Where are they going to perform? I stayed in an apartment just outside of Wembley Stadium, and it's a free concert every weekend. You just open your windows and you get to hear. The hardest thing I listen to is Daughtry. Could be worse. Could have said Nickelback. Oh wait, Lauren did. Nickelback. There you go. Don't hate me. I like Nickelback. I like to give them a hard time too, but they have some good songs. They're just not musically complex, like Dave Matthews is. Still waiting for the judge to come back. When he left us, he was angry at somebody who was in court and caused an outburst, disrupted the proceedings, then proceeded to walk out, ignoring the judge's order to stay where she was and come back. And he had to send the bailiffs after her. She's now sitting in the box in handcuffs. We're waiting for the judge to address the issue. Let's see. Pantera, Fishbone, George Strait. Pantera and George Strait. Love the mix. Last concert was Metallica, says Donna. Love Nickelback. I was always teased. I like him as well. I think I even have, I might even have Nickelback. I can't play it, but I think I have some of their music on my phone as we speak. Let me just see who's on my playlist here. I've got some crazy stuff on here. I've got Cell Dweller, Dave Matthews Band, Diamond Rio, Evanescence, Jack Johnson, Jared Meese and the Grown Children, Lindsey Sterling, Muse, Philip Phillips, Saliva, Cedar / Trevor Hall. Oh, I've got some good stuff on here, but no Nickelback, unfortunately. Oh, Brad, the lead from 3 Doors Down, has lung cancer. Oh, that's terrible. Oh, the Eagles back in the good old days. That would have been amazing.
Report County of Washington, State of Michigan is now back in session.
Okay, we're back.
You may be seated.
Young ma'am. Young lady. You want to bring her out? Oh, no, he's just going to pick up. She's going to sit.
There's an in custody. Dontrell's. Okay, thank you.
Court calls the case of the People versus Earl Covington.
Brought out Assistant Prosecuting Attorney on behalf of the people.
Assistant Public Defender Davy Lebo on behalf of Mr. Covington. Once you get the Lebo look if he's walking in.
Come on.
Could you state your name, sir?
Earl Covington. Thank you, sir.
And you're going to be requesting an adjournment today in order to continue some discussions as well as get some additional information.
Probable cause conference, I'll set it for January 29, 2026, 9 a.m. Or as your invite indicates.
Thank you.
And will continue. Thank you, sir. He's adjourned. Court does call the case People versus Dontrell Smith.
Dontrell Smith.
Your Honor, Mr. Pillwall had to go back to his office real quick so he can touch that.
This is not Mr. Pillwall.
Oh, I'm sorry.
I'm ready to go. Mr. Smith is in custody.
Pardon? I don't have it.
Brian Bowling on behalf of Mr. Smith, he's in custody.
They not respond, yeah.
They're not responding.
They don't have some,
Dontrell Smith is in Zoom. They have turned off their.
I know, but now the camera's on.
You ready for Smith, Your Honor?
Yes, sir. Yes, sir.
All right, we'll get him.
How many officers does it take to set up a Zoom camera? Oh, we're going upstairs. Upstairs, cell block F.
Hey, Smith, come on. You ready?
Guys, call the case of People versus Dontrell Smith.
Brian Bowling on behalf of Mr. Smith. Mr. Smith, can you state your name, please, sir?
Can you tell us your name, Mr. Smith?
Dontrell Smith.
All right, thank you.
I'm asking for an exam, Judge. I believe all discovery to be complete.
People have their witnesses available the 20th. Preliminary examination will be set in person, January 20th. Is that right?
Yes.
2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Brandon Myers.
Radiohead in London. Ooh. I think I know some good Radiohead songs.
Glenn appearing on behalf of Mr. Myers. Can you please state your name for the record?
Brandon Myers. Thank you, sir. All right, what are we doing?
We would like to request an adjournment, and when appropriate, I'd like to address bond.
Do you have a green sheet? No.
Oh, yes. I will.
Probable cause conference in these matters will be adjourned to January 22nd, 2025, 9 a.m. All right. Yes.
Okay. Your Honor, we are requesting that Mr. Myers be released on a PR bond with a tether to his grandmother's house. I'm sorry, to his mother's
My
house.
mother's in the courtroom too.
Hey, Mom.
She has a lot of health needs and she has,
Is this the same motion that I already denied?
We've never done a motion.
Oh, yes, you did. The motion on this, a motion to modify his bond, which I denied on December 11th. But go ahead.
Is that enough? She's in the courtroom?
Yeah. He wants me to let you know again that his mother is present today. She has a lot of health issues, including her vision is severely impaired. And Mr. Myers is her support system. He takes care of the house. He helps his mother get to and from her medical appointments. He has a strong tie to the community. He has a positive support system, which includes 3 of his family members are here today. And
You went to school with her.
he also states that you went to school with his mother as well.
Pardon?
You went to school with my mother.
I did?
You seen me in 2008 and you said you did know my mother. She's right there, the light skinned lady.
The light skinned lady? Really? Which one do you want me to pick out?
The one that's laughing right there.
Okay.
Her right there.
Hello. Okay.
Okay.
You went to school.
Your
with
Honor,
my
we
mother.
believe tethering him to the house would keep him from interacting with the complaining witness. And he is well aware of the PPO and in this court's direction to have no contact with the complaining witness.
You know I don't play with him either. I don't play with you either. You know that.
What?
No, I don't give you no hard time either. I do what you do.
People can give me a hard time. When you go back, you can ask that young lady.
When you go back.
Is there a response from the people?
Your Honor, since this motion was already brought about a month ago, we asked the court to denying it and just highlight the facts where the defendant is reported to have come to the victim's house, threatening to kill someone if he sees. Also showing up at the victim's church, creating where he also.
That's a lie.
That safety of the public is necessary. That bond should be continued.
That's a lie.
I couldn't nobody.
All right. I've already heard the motion and ruled. I don't hear anything different. If maybe there's a conversation had with the prosecutor and there are certain conditions that will alleviate their concerns, then maybe the parties can stipulate to something, but I'm not at this point going to change the bond or the court's decision. The motion for bond reduction is denied.
Thank you, Your Honor.
All right. When are we going to bring her out, Judge?
Court calls the cases of the People versus Bernard Lee Fonville.
Cases.
6 cases.
Whoa. Picked up 6.
No.
I see green sheets and looks like
Mr.
we're
Fonville, will
asking
you state
for
your name
a
for the record?
continuance.
Thank you.
Thank you.
Your Honor, we're asking for an adjournment to review discovery with Mr. Fonville.
Is it extensive or is it?
No, there's just 6 files to review. So
Yeah,
just
that's what.
a couple weeks. I provided him a copy of the discovery today. So
Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continued.
thank you.
Thank you.
29th. Thank you.
Court calls case People versus Johnny Charles Payne.
Michael Gaddy, Assistant Public Defender. Payne is approaching
Your name, sir?
Johnny Payne, sorry.
Thank you.
Yes, Your Honor, I've had a chance to speak with Mr. Payne and with Mr. Cook. Your Honor, I'd ask Mr. Payne has a parole hold I need to investigate. We were going to set this date, for example, but I'd ask the court to adjourn it so that I can continue trying to reach his parole officer.
The 22nd or 29th?
The 29th would be good, Judge.
Probable cause conference January 29th, 2026, 9 a.m. Bond continued.
Thank you.
We need Kusi to have his case
Court calls the case of the People versus Carlton Cross.
Thank you.
Carlton, here he is.
Assistant Public Defender Davi Leba on behalf of Mr. Cross.
Mr. Frost.
Hello.
Hello.
Hello, what's your name?
My name is Carlton Dion Cross. Thank you. You're
Thank you,
asking
sir.
for an adjournment for additional discussion.
I am, Your Honor. Thank
Probable
you.
cause conference, January 29, 2026, 9 a.m. Bond concluded.
Thank you, Your Honor.
Thank you, sir.
Thank you, Joe.
False case, People versus Adam Perella.
Assistant Public Defender Davi Leba on behalf of Mr. Perala. Could you state your name?
Adam David Perella.
Thank you.
And Your Honor, we would like to set this matter for preliminary examination, please.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 20th. Preliminary examination in person, January 20th, 2026. Sorry. 9 a.m. It's going to take me a minute before Judge Freshour.
Thank you, Your Honor.
Bond continue. Thank you.
I think I fixed the
Court calls case of People versus
the commands. Test some of the sounds.
Zakara Daphne Bursiaga.
It's quite a name, Judge.
I expected this to be called when you took that pause, Judge. So,
Yeah.
Brian Bowling on behalf of Ms. Daphne Bursiaga, Your Honor, can you state your name for the record?
Zakara Daphne Bursiaga.
Exactly what I said. I'm pretty proud of me.
She brought the Bible.
Your Honor, we're asking for an adjournment for ongoing plea discussions in this matter.
Okay. Council Roach. No, this is.
Judge meets the mic to talk at sidebar for a minute. Okay, points are working. I think the commands are working again. I think Carlton on Fresh Prince and his dancing. That's where the Carlton was from. Got a stubby little pencil. Gringer's is working. All right. We're going live again? No audio? Judge?
It's due February 5th, 2026, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue.
She's wearing a long coat, like all the way down to her ankles.
Case of the People versus Jack Saunders.
And we have People.
Must be cold in Michigan.
Stephanie Cannon on behalf of Mr. Saunders, who's approaching. Mr. Saunders, could you please state your name for the record?
Jack Lee Saunders.
Your Honor, we are asking for a 2-week adjournment in this case for plea negotiation purposes.
Without objection, January 22nd, 2026, 9 a.m. Bond continue.
And Your Honor, there is a violation.
Is there?
It's my understanding.
Our violation was from that time you failed to review.
Yes, basically, yes. And there's, well, it says a lot of stuff.
Here's a bond violation, no bond.
Yes, Your Honor. So we are going to ask for a hearing as to the violation. My client had double pneumonia, and so for a chunk of this, he was just in the hospital. And so we got to get
have proof of that.
We're getting release of information for University of Michigan and for Trinity.
So when I
for the
spoke 22nd at 3 p.m.
122, Your
And
Honor.
I'll set a hearing on bond violations at that same time.
Thank you, Your Honor. Perfect.
At this point, his bond will continue. Thank you. Our call's case, People versus Juwan Daniels.
And Mackie on behalf of Mr. Daniels.
Your name, sir? Juwan Dames. Thank you.
Your Honor, requesting to adjourn this matter.
What is it with you and the green sheets? What is the issue? You know the routine.
It's been a while, I think. It's been a whole year since I last seen you.
No, that was last year. That was not a whole year. That was good though. She was
officer of the court line.
probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continuing.
Thank you, Your Honor.
Thank you. Court calls the cases of the people versus Kirby Snyder.
Chadwick, people.
Veronica Glenn on behalf of Ms. Snyder. Please state your name for the record.
Kirby Snyder.
Your Honor, we would like to request a 1-week adjournment.
Why 1 week?
We need time to get discovery.
Is there anything else holding her? Because I'd give her 2 weeks, but 1 week is really for emerging circumstances. Nothing else is holding. We don't know why you asked for 1 week. Cannon sent you up here to say, do 1 week because you know that'll irritate him.
We need discovery. That's all I have.
That's all you have?
That's all I
They
have.
just sent you out there, threw you to the wolves. They need to treat you better. I'll adjourn it 1 week because you asked. There might be a reason. Oh, no. January 15th, 2026, 9 a.m. And because you at least have your green sheet, Ms. Mackey.
Thank you.
I don't even know what cases, if she do it.
One right before this one.
Yeah, I know, but I don't even know if we have the file. Court does call the case, People versus David Davenport.
Good morning, Your Honor. People.
We have a green folder.
Glenn on behalf of Mr. Davenport, can you please state your name for the record, please?
David Davenport. Thank you.
Your Honor, we would like to set this for a preliminary exam.
All right. Discovery is complete.
Yes.
Oh.
Your Honor, I don't believe discovery is complete. I discussed earlier, originally we're going to set for exam tonight. I thought we discussed a second time we were going to adjourn for that discovery. It's not that.
Your Honor, Stephanie Cannon on behalf of Mr. Davenport.
So you didn't give the information to Ms. Glenn?
I did.
No.
I did
That's
not,
a
Your
yes or no response. Don't
I-
worry about it. You're not in trouble.
That is correct, Your
What?
Honor.
That's a yes or no, right?
Yes, it is.
You did not give the information to Ms. Glenn, and so she took the instructions that she had them.
Yes.
Correct?
That is correct.
Okay, now that we know that you have fallen down on the job and that there is needing to be an adjournment, you can sit down.
Yes, no.
No,
you
I
can't
don't need
sit
to hear
down.
from you. Sit down.
You can't-
Sit down. I don't need to hear from you. I'm only going to hear from Ms. Glenn. Don't try to whisper in her ear what to do. I'm going to adjourn your case out so they get all the discovery.
Okay.
What's going
Your Honor, we would
on?
like to request an adjournment. We also would like to make a request to allow him to return home.
Probable cause conference will be adjourned. Well, where's home?
Where's home, Mr. Davenport?
Ann Arbor,
Ann Arbor?
3310 Fernwood Ave.
Oh, he wants to return to his home address.
Yes.
It's not like, you made it sound like he lived in another state. I'm like, what state is he? Where's he? Okay.
And Your Honor, people were looking for the victim that they are no longer living there, so I would have no objection to allowing him to return home and lifting the no-go too.
Motion for modification of bond in terms of the no-go to. granted because of Miss Glenn's wonderful argument that was made.
Thank you.
So you may return. The no-go to will be lifted on that. And I will adjourn, given that, I'll adjourn this matter out January 29th, 2026, 9 a.m. or as your invite indicates, bond will continue. Thank you, sir.
Thank you, Your Honor.
Thank you for your patience with Miss Cannon. Court calls the case, People versus Alicia Whitberg.
Assistant Public Defender Jay Bellinger on behalf of Ms. Wittenberg, who approaches, Your Honor. Only today, after emailing them 7 or 8 times, have I heard back from them. So unfortunately, she hasn't even been processed yet. When I spoke with Mr. Reyes from that court, he advised that he didn't even know that she was in custody. So that as well as the fact that you submitted it, you signed an order for her release to treatment. I've tried to be in contact with Sarah Stewart, who is handling her case. I submitted that on day 1 as well when she went into custody. Sarah Stewart still hasn't gotten back to me. It's been 7 or 8 times that I've contacted her. Ms. Wittenberg has been in for the last 28 days. As I stated, she was in on a bond violation. Your Honor, at this point, I do need to adjourn her case for the processing of the 14B Recovery Court referral. However, I am going to again renew my request for her release. She is working in intensive outpatient therapy with U of M. She has submitted that to the court prior as evidence. I want her to be able to be processed in one way, shape, or form as soon as possible through no fault of her own, as she's just sat in jail.
Well, yeah, I know. And my concern is I realize there are delays trying to get people into treatment. There are 2 avenues here where something should have happened and nothing has.
Yes.
That concerns me.
Not yet, if any.
And I would prefer, quite frankly, if there's going to be a process where she can get into a recovery court, that's going to be the best shot for her, right?
Certainly.
So
Mr. Reyes did advise, because he didn't know that she was out of custody, that he could, if she were to get out of custody, he could give her a call and set up an appointment by Friday.
In custody?
If she's in custody, he said he would need to set up an appointment with her that they still haven't unfortunately done.
Turn her out to the 22nd, 2026 at 9. At this point, I'm going to continue her bond. I will consider something different if she's not, if we're in the same boat on the 22nd. I will certainly look at some way to do this differently so that she can get assessed. She's just waiting. I don't think she should have to. I get if there's not placement. I get if decisions aren't made, but at least this is a preliminary part of assessing. We need to be able to get that done.
Yeah, I know that she stands to lose a lot, including her job, Your Honor, and I know that she wanted to speak to that aspect of it. I don't know. I know you've already made your ruling, Your Honor, but
what do you want to tell me, ma'am?
The only thing I was going to say is I do have good private insurance, and that's, I have called myself and was told that I could get in under my own private insurance, but unfortunately, because I'm in here, I can't. If I was out, I'm just feeling like it could be faster than waiting.
Here's what I'll do. I'm going to set it for the 15th. Somebody needs to do that. Mr. Manager, if what she's indicating, get me some information that says that she can't do it while she's in custody, and then I'll reconsider everything. But I'll just put it out 1 week for him to get that. We'll take a look at it. Fair enough?
Yes, thank you.
You're welcome. Thank you. Court calls case People versus David DeLucia.
Assistant Public Defender Chelsea Virgils with and on behalf of David DeLucia. Please state your name.
David Mark DeLucia.
Right. I'm very close.
Your Honor, he will waive his right to a preliminary exam.
Is that correct, sir?
Yes.
You understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to you'll proceed to circuit court for further resolution.
I understand. Yes.
People also waive their right.
Yeah.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
Acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. Pretrial will be set for
30 before Judge Conlon.
March 4th, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you. Does call the case, People versus Antonio Williams.
Good morning, Your Honor. David Cook for the People.
Morning, Your Honor. Michael Gandy, Assistant Public Defender for Mr. Williams, who's being brought in.
He is being brought in.
Yes, sir. Thank you. You're requesting an adjournment?
Oh, yeah, well, Your Honor, this is a time for a competency review.
Yes.
I don't think we're near the 15-month period. I think it's a 10-year max on this matter. We did contact the forensic center. They said they met with Mr. Williams on the 18th of December, but they haven't completed the report yet.
Got it.
I wasn't able to get a date as to when it would be done.
All right, why don't I do this? Because we can always move up to date. Why don't I comp review? I'll adjourn it out to, I don't want to go that far, but I'm going to go February 26th. If we get a report, we can certainly move his case up.
Thank you, Your Honor. I'll come back and see you.
9 a.m. Bond continued. Thank you.
Your Honor.
Yeah. Is he talking?
Yes, he was. I think he had a question.
Did you want to say something to me, Mr. Williams?
Yes.
What do you want to tell me, sir?
Bring it back to the mic.
I need a way to make a phone call. They won't let me make a phone call without money on.
To tell what?
They won't let me make a phone call without money on.
Oh, okay. And
nobody knows I'm in.
So there's somebody that you want to call to let them know that you're in?
Yes.
Okay, so here's
I've
what.
been here 6-7 months and nobody knows.
Okay, and you know the phone numbers of the people?
No, I don't.
Okay,
I
so.
know what, it's the Elk Swim Club Card Club.
Okay, so here's what I'm going to tell you to do, Mr. Williams. I think what you should do is give a list to your attorneys as to who you want to have contacted to let them know that you're in, and let your attorneys follow through on that for you, okay?
Will they do it?
Will they do it? Is that what you're asking?
Yes.
I would suspect that they would. If they believe that it's in your interest, they will do their best.
They haven't in the past.
Your Honor, this is a matter that Mr. Williams and I did speak about yesterday.
Oh, you've already talked about it?
Yes.
Okay, all right. Then let them take care of it. And then if they don't, then you can let me know in February, okay?
Or I could bond out of jail if I could get to this.
To these people you might be able to bond out?
Yeah, I would.
Then certainly your attorneys are gonna do everything they possibly can. I can tell you that for sure. Okay?
Thank you.
Thank you. Court calls the case, People versus Robert Dolan.
I hate the jail phone
And your children can hang on behalf of the people.
money scam. We lock somebody up and then charge them money to communicate. Don't like it. I realize you can't just, there are some expenses. You can't just be.
Just very bad. Mr.
Allen says, "Why are you wearing your glasses? Take them off."
Mr. Lebo, where is he? We have you on this case.
Oh, is this Mr. Dolan?
Dolan. It is.
Apologies, Your Honor. I didn't quite hear the case name.
All right.
Assistant Public Defender Davy Lebo on behalf of Mr. Dolan. Mr. Dolan, can you tell the court your name?
Thank you.
And Your Honor, we did receive some media on this case. I'm going to need some time to review, so I'd ask for perhaps a 2-week adjournment.
Pardon?
We have some media that that would need some time to review, so I'd ask for a couple weeks adjournment, please.
January 29th, 2026, 9 a.m. or as your invite indicate. Bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Terrence Ginyard.
Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Your Honor, I'm just going to hold the door open.
Okay.
Because he's on crutches, sir. He's got a boot on one foot.
Mr. Ginyard, can you please state your name for the record?
Terrence Michael D. Allen Ginyard.
And Your Honor, we're here for PCC today as well as the community corrections warrant. And I just want to first start off with the PCC. I am still working as fast as possible. I've talked to Mr. Cook about this case. He was just assigned to it after Mr. Overwater. So I am working to get a resolution as quick as possible on this. So I would be asking for adjournment for 2 weeks.
I'll adjourn the probable cause conference to 22nd,
As
2025, 9 a.m.
26, Your
The
Honor.
bond violation.
As to the bond violation, Your Honor, I did send into the court some a urinalysis as well as a lab that was taken for blood that goes back 2 weeks in response to the allegations that he was testing positive.
Where do you have that? Where do I get the indication that this test goes back 2 weeks?
May I approach, Your Honor?
Yeah.
It's going to be on the
Judge goes sidebar. The girl that caused the outburst in court is still locked up in the holding cell there in the courthouse. The judge will probably work till the end of the docket before pulling her in. Just letting her sit, letting her think about it. I don't know how old she is. Which is interesting. But either she's coming to her senses a little bit and will come in quite pious and apologetic, or she's probably going to ramp up, and just be angry at the world for how she was treated unfairly here. So we'll see which one comes out. All right. Yeah, he hasn't forgotten her. He knows exactly where she is. Or she'll play the victim card. You think she will? She might. She might say sorry with an excuse, which is like sorry, but I'm not sorry. Instead of just taking ownership. She could end up with multiples of 93 days and $100 fines. I bet he just lets her go at the end of the day unless she acts like a bad girl. I'm the bad girl. Do-do-do-do-do-do-do. Yeah, a little Billie Eilish for you. You know I'm a fan. Such a power move. It is. What did she say that made Simpson mad? I don't think it's what she said so much as what she did. She did cause a disturbance, and he basically told her off and said, "Come here." And she turned around and walked out. And that's probably the bigger issue. The direct disobedience of a court, the court. Yeah. So now she's thinking it over. Can anyone get Mr. Williams' first name? That man needs money put on his books. I want to help him. Annabelle, I know there's a mental competency issue at play as well, and his lawyer is involved in that. The dates that the lawyer gave, the lawyer said they were working with 90 days. He says he's been for 6 months, 6 or 7 months. So there might be some confusion there on the part of the defendant. It is sad, though. I don't like the system. Is it lawful to hold her this long? Yeah, he can. He could probably order her to serve time right now. Judges have a lot of authority when it comes to their courtroom, and where she disobeyed an order, if it were just like an outburst, it's like, hey, you can't cough in my court, go to jail. That would not stand up to scrutiny. But where she caused a disturbance, he called her on it, told her to come up here to address the disturbance, probably just give her a talking to, saying you can't do that in court, be respectful. And she disobeyed and direct order and just left, and had to get the bailiffs, like a whole team of bailiffs, to round her up. She might be thinking this one for a while. We went back and watched it as well. It's right before the break. He hasn't called her back. We're sort of sitting here waiting to see when that happens. We can't go to lunch yet. Hey, how's it going? The blue snippers, they should be next to the 3D printer. I don't know. We're still on the crutches case.
Okay. All right.
What I'm going to do, record to reflect to have bench conference in this case. Right now he has a no bond bench warrant because of 2 tests. I've received other information that quite frankly isn't inconsistent with the testing, because it could be low. His testing could indicate low or no use within the past 2 weeks. I will adjourn this matter out, set it to the 22nd. I'll adjourn it out 1 week to the 15th, 2026 at 9 a.m. At this point, however, the defendant's bond is revoked. I will indicate that based upon the request from counsel. Once I can get a straight story on this, then I will consider at that time his release on a scram tether as opposed to the sober. But at this time, defendant
remanded to custody. He and his crutches are going to jail.
Right.
Letting you know that.
Your Honor, can I speak 1 second? I'll make it quick. So on here, I don't think what you did see, I know it says that the CDT result 1.4 is consistent with low or no alcohol. But at the top, it says my current result and flag is 1.0, which means it's under the 1.4, which could be low or none. So my test is 1.0. Okay.
He did read it.
All right. That's all, sir. That's all I want.
And I also know, so that the record is clear, that on the sober link on 2 occasions, you tested positive, and on the retest, continued to test positive.
Understood. That's why I pay for this test, though.
I understand why you did it.
Yes.
But I'm saying, I'm telling you how this looks.
Understood.
All right. And the only reason I may consider release is because of the advocacy of your counsel. Because normally I wouldn't consider release. Normally what I would do is I just revoke your bond and you're going to sit there.
Yes, sir.
But I'll bring you back in a week and we'll look at it again.
Yes, sir.
It might be as late as tomorrow morning. But we're going to keep an eye on the duck.
Let them go back. Okay.
You say
I put it out, instead of 2 weeks, I put it out 1. To the 15th. Yeah, it's a Thursday, the 15th.
at what time?
Well, I set it all at 9. It'll go into a block. You can talk to his attorney. They'll figure it out. Okay? You're welcome. Court calls the case People versus Devon Reed.
Or Devon. It's
Brian Bowling on behalf of Mr. Reed, Your Honor. Devon.
Devon Reed.
Judge, I'm asking for an adjournment. If I
Wearing a
could.
Georgetown shirt.
So that, I think we've got the issue with respect to the video discovery ironed out, with Mr. Chavalowski. So I just.
You have it ironed out.
I believe.
Get it? Okay.
Yes.
All right. January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you.
Thank you, sir.
Court calls the. Yeah. Refusing. Court calls the case People versus Stephen Giffen.
Refusing?
Abound.
What's going on?
People.
Someone's refusing to show up in court?
Given, yes. He's refusing to come up.
He refused to speak with me as well, Your Honor. I do have a green sheet for his behalf, on his behalf. The prosecutor and I have discussed this case, not to a point of resolution, but we are trying to figure out the next steps.
This is set for confidential review.
Your Honor, it's my understanding that he has as of yet not spoken with them. He's refusing to speak with anyone.
He's in jail.
All right, then I'll adjourn it out. See what you guys can come up with. Adjourn out February 5th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
I like it.
Court does call the case of the People versus, this is Donovan. Too bad. Oh, there he is. Donovan Smith. Well, they got.
Good afternoon, Robert J. Kill on behalf of Mr. Donovan Smith. Donovan, would you state your name for the record?
Different Donovan.
Donovan Smith.
Okay. So here's what I'm going to do, best I can try to come up with. Is he going to want exams on these? Is that the deal, or what?
Oh, especially the CCW.
All right, that's fine.
Yes.
Carrying a concealed weapon.
So I've got the paperwork. What I did is I took the one that they sent back. You got the CCW here. Are both going to be requested for exam? So what I did is that rather than wait till next week, I got the paperwork. We're going to deal with it. What we're going to do today.
Okay.
Okay. So I'm just not going to wait a week. So I'm asking, what do you want to do on both of these cases?
You want to go to have exams on these?
Is it both at one?
Huh?
Is it?
Let me just say this also. Because the one that was a waiver was assigned to me, it has to come back before me.
That's fine.
So if you set, oh, thank you. But so if it's set, Norma, my next date would be February 3rd. But given all of the circumstances it is, and I'm not sure why things are happening the way that they're happening. I'll give you a special date as soon as I possibly can to put it before me.
That's fine.
Okay. So do you want exams on these?
If not, let's go that.
Well, we can either wait back up to circuit court. Yeah. Okay. Well, then we need exams, Judge.
You want to?
Yes, my client would like to have exam.
All right. And I think it's more important. Mr. Smith, you understand what I'm trying to do, right? Okay. So normally if I were setting today, it would be the 20th, but I'm not on the 20th. What do we? On the 20th, I can, if the other courtrooms are empty.
Correct.
I can do that. Okay.
Correct.
All right. So I'll set it as though you're asked. So I'm taking a week's time. Okay, best I can do. So I will set the preliminary examination in person. I'll set it for January 20th, 2026.
Is the defendant fine?
You want me to do one?
Sorry, that was me.
Yeah, let me put it at 1 p.m.
Judge, Not to cause any problems, I have a full docket with Judge Kunke that day. Is there any chance?
Well, she could have kept this one and you could have been on it. I'm sorry.
Is there any
Shouldn't have
chance we
said
could do
so
that
sweepingly. Go ahead, what?
Is there any chance we could do it in the morning of the 20th?
No, because what's happening,
still
the
on
other
holding
judges are in my courtroom.
Okay.
And that's the best I can, are you gonna be there all day on the 20th?
I have 4 cases, yeah. Sentencings and show causes.
Give me another date, but it's gonna have to be before the 20th. I'm not gonna have it.
Okay, so we could do the 14th, Wednesday, the 14th.
At 3?
Oh,
yes. I like to go home.
What was that?
You want for the 20th, yes, sir? Or you-
Right.
Okay, so it would have to be Wednesday, the 14th at 3 p.m.
Is the next time I have.
That's what my client wants, Judge. I'll know this afternoon if I'm going to trial on the 12th, but let's just schedule it for the 14th.
All right. I'll set it for the 14th. Pardon? I have prelims on the 13th? Well, what the hell? I mean, heck. My apologies for that. Why didn't you just tell me? I thought I did. I'll just set it on my prelim docket. January 13, 2026. That'll be at 9 a.m. What were you guys doing?
Judge, just for the record, I'm pretty sure if my trial goes, I'll have to.
What were you guys? What? I know. So? What?
He's talking to his staff here.
What were they doing? I told you I didn't want him waiting. I had the 13th. No.
The 14th, still before the 20th.
I had to do this the last time. Stop talking. 9 a.m. That's before me. So we're going to get you in before even the time that was set for the case coming back. Now, the issue regarding bond, and I need to figure this out. At the time, on the case that went up and has now come back, I gave him a personal.
No, you gave 10% bond.
10%.
50,000 cash surety. He was going to post it that day, but that day also the new case came in. That case has a $25,000 cash bond. So right now he has a $50,000, 10%, 25,000 cash. We were asking if the court would consider 10% on.
So, right. I got you. So the one he was going to post, he is still in a position to post that one, right? So, am I right?
50,000. Yeah.
The 50, you could still post
10,000. 10%.
At the time that the agreement was made, him waiving and reducing his bond, were the people aware of that other case?
Judge, I can tell you that I authorized a charge on the 19th to put it into play. I didn't get the money until 29th.
30.
No. Here's what I'm asking.
Who's this gamer girl?
Judge, for what?
I hate the days I'm talking French because nobody's understanding me. Listen, when he waived up, what date did he waive?
It's going down, guys.
23rd of December.
Gamer girls here.
And that's when the agreement was made to reduce his bond.
Yes.
Correct.
So then this other case is out there.
Corey's back, and the judge sealed it.
Based upon those dates, the people were aware of that other case when the agreement was made to reduce his bond.
Yes.
Good. That's all I need to know. So on his new case, carrying a concealed weapon. He's gonna post on the other case. I'm gonna set that for preliminary examination. I'm just going through, making sure my paperwork's clear. The 13th, 2026, 9 a.m. before me on that case. On the court's own motion, that way I'm doing it because I think it's fair. I'm going to reduce his bond to a $25,000 personal recognizance bond.
It means that's a PR bond, but if you don't show up to court, you'll report 25,000.
So if he can post the other one, he can post the other one, and we're going to be back right where we're supposedly supposed to be, except that you're not in circuit court, you report me.
25 grand. Thank you very much for your consideration.
Got that? Okay, we'll see you on the 13th. And if you get out, don't do anything stupid.
I'm not.
You hear me?
Yeah, I don't even live in Ipsy.
Well, you
I'm
going to do
gonna come
something
back
stupid
down.
someplace else? I just said, don't do anything stupid. I don't care where you are. Got it?
Yeah.
Thank you.
If you get out, don't do anything stupid. I don't even live in Ipsy.
They are.
You can do
Court
something
recalls
stupid
case
someplace
People
else.
versus Tanisha Ayden.
Good afternoon, again, Your Honor. Looking at people.
So someone to better than Apple during the problem is This is virtual now. Ms. Higgins, will you state your name for the record?
Tanisha Aiken.
He's waving.
Yes, Judge, she is waiving. There is an agreement to HIDA on both files. Additionally, the 25 F2 1212 file, there is a misdemeanor offer if she is able to pay a portion of the restitution, but we'll do all of that in circuit court. But the people are not objecting to HIDA.
All right. Ma'am, you're waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on all three counts in the two cases.
Your Honor, we acknowledge receipt of the information. My client would stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Both cases, pretrial will be set.
March 2nd at 1:30 for Judge Mood.
March 2nd, 2026, 1:30 before Judge Hamoud. Yeah. And we'll continue.
Okay, thank you, Judge.
Thank you. She's gonna sit for a minute until I come back out. I gotta figure out what to do with her. All
She's
right,
gonna sit
that's it for
again.
that block. I gotta come back. The 12:30 block supposedly supposed to start now. We were right on time until whatever. So you're gonna have to give me 15, 20 minutes. I gotta let my staff have a break, let people get a bite to eat, and then I'll come back. Court stands in recess. All rise.
Edward Gross is shaking his head. It's like, whatever. Oh, Brittany's gone. When they said all rise, and the people on Zoom stood up. Got a little belly show there. Brittany's gone. Randall's just a little puff pass going on up there. Not sure what he's smoking, but apparently it's the good stuff. Gamer Girl up there on the top. I'm not sure if that's her like YouTube name or what, but 15 or 20 minutes. Yeah, what can you get in 15 or 20 minutes other than indigestion for lunch? Gamer Girl she's like, well, if the judge can be 15 or 20 minutes, I can get Call of Duty run in that time. Let's jump online, get some game time, right? I don't know what she's doing. Got a ceiling fan. Cold pizza. That works. She probably got that sign from Five Below. Randall is mad. Edward Gross is mad. Ooh, what's for dinner, Mr. Kaba? What is, or I guess lunch in this case. I missed what he put in his mouth. What is he eating? I don't think that's gum. I think that's like a full-on meal. Dropped a piece on the floor. It's all right. 3-second rule. Still good. Still good. I think it's chicken. It's very chewy, whatever it is. Might be a Laffy Taffy. Lamine. Is it Lamine? Oh, it's a snack. It's definitely a snack. Eating it by the handful. It's a chewy snack. What could it be? Skittles? Oh, I think you're right. Mr. Gross is in the driver's seat. Possible seatbelt. Is that what I see? M&M's for sure. No, they're chewy, unless they're like caramel M&M's. I'm thinking Skittles is right. Maybe if he shows us his tongue, well, I don't want to see, but if he does, we'll know if it was like tropical or berry. Now he's got the Skittle eye condition, where you get Skittles in your eye. Gummies for sure. He's eating gummies by the handful. Edward Gross now showing that he's in fact on the International Space Station, looking down on the Earth from high above. Going to raise the question of subject matter jurisdiction when his case comes up. Hopefully not the weed gummies. Could make the hearing quite interesting. Who's behind me here? Randall? Randall's happy. Makes me wonder what he was smoking. Another ceiling fan. Ooh. They're noticing other people are turned off their cameras and they're like, I can do that? Didn't know that was a thing. What does his shirt say? Do I want to know what his shirt says? Can you guys read that? I said he's eating sunflower seeds. And just shells and all? It's like eating the peel of a banana. I think Mr. Randall is at the drive-thru. He struck up a conversation with the drive-thru worker, and they're hitting it off. So I discovered Abby Crossing. I think that's what it is. Abby, welcome to the gallery. Brand new member. Thank you for joining us. Thanks for becoming a member as well. Supports the channel, makes it possible to do what we do. You can get sunflower seeds without the shells. Yes, but they don't take as long to chew. I mean, it's got to be something chewy. It's got to be caramel or taffy or something. Long-time listener, first-time caller, Abby. Thank you. Thanks for joining us. Milk Duds. I don't know. He's holding them in his hands. Milk Duds would sort of melt in your hand a little bit. Man. So I don't recommend this, okay? I don't recommend this, but I'm sitting here. I was on Twitter following a case, and I saw a tweet that caught my attention, and suddenly I went down a rabbit hole. I've ended up on a website called Pollingmarket, which I thought was a polling company. Like they do polls to see what people's opinions are. No, it appears to be a gambling site based on anything you want. Like Venezuela or Greenland or Ukraine or tech. Which company has the best AI model at the end of January? And you vote with money, And if you're right, you win. I don't know how else to say it. You bet on climate, science, economy, world, culture, earnings, geopolitics, finance, crypto, sports, and more. I mean, like some of it is like, will Mr. Beast's video get 31 to 32 million views during day one? There are people betting on that. It's a betting market. I just found this. It's a site to bet on anything. Oh, Brittany Fisher is back. Brittany Fisher teaching the naturalization class at the local community center. Does look like she's almost in a courthouse with the flag behind her. Admiralty flag, as you can see, it has the fringe. Liking the chair Mr. Kaba has. Like the wrought iron and wood mixture. It's looking good. Randall is still placing the world's largest drive-through order. It's a safe bet. I'll catch a timeout or two each day. It happens. I think chocolate-covered raisins might be what Lemine was eating. I'm still trying to figure out what Kalisha's YouTube name is. If she's a gamer girl, or maybe she's a Twitch gamer. Not sure. Samantha says, hands up if I return daily for RA commentary. Just like to watch. Oh, Olivero has awakened. I think I disrupted her. Sorry, ma'am. I didn't realize you were sleeping. All right, Mr. Kaba puts the phone down so we can't see whatever's about to happen next. Lots of ceilings. Lots of nothing showing. I want to bet on whether they will solve the trolley problem this year. I say no. Okay. Well, we can in fact view a couple other courts while we wait for Mr. Simpson, for Judge Simpson's court to come back. Let me take a quick peek around the world of true crime. See what's happening. Clinton Circuit Court, Commonwealth of Kentucky. That was the Mumble Court. We're not going to go back to that one. I don't know about this one. The beheading trial. Do we want to do the beheading trial? There's Simpson. My whole live stream is filled with 3D printing videos. Battleground, Michigan. What's up with Battleground, Michigan? I haven't been there before. Let's see what we have. I think it's Michigan. Yeah, it is. Oh no, it's Washington. Excuse me. Battleground, Washington.
During the event, repeated contacts, frankly, I think there's potentially 3 separate assaults in this case. And so the city is requesting enhanced pretrial release. It is just very concerning behavior. The victim has indicated that this is not the first time this type of behavior has occurred, simply the first time she's reported it, and has noted significant concerns for her safety. So.
Yep.
So just to make sure I'm understanding, in regards to the victim notification prong only, I understand the rest. The victim is requesting that condition?
The victim didn't request that condition specifically because I don't know if she's aware of that. I believe it's necessary based on the conversation my legal assistant had with her and the concerns she raised. I believe it's appropriate. There was an attempt to prevent her from leaving the residence. She's indicated concern that if she's not protected, she will not be able to get away from Mr. Webb. And I don't think a piece of paper is sufficient.
Mr. Wallace.
Thank you, Your Honor. Mr. Webb will stipulate to a no contact order and would intend to follow it. Other than that, we would ask that he be released on his own recognizance, that the court not enter an order for the GPS monitoring. And the reason for that, Your Honor, is that my understanding is that's an $800 a month expense. And
800?
While there seemingly could be notifications that arise from that, it wouldn't offer any actual additional protection than the no contact order will. And that's already going to be in place. Defendant doesn't have any DV conviction history. It looked like maybe there was a charge in 2016, but that was dismissed. He lives in Ridgefield now with his sister. He grew up locally. He's employed doing some masonry work locally as well. So he has ties to the community, and any risk that he theoretically could present to the alleged victim should be placated by this DV no contact order that the court's entering. With regard to that no contact order, I think we're stipulating to a civil standby. I've marked that in the document. My understanding is there's a truck full of belongings, but also additional belongings inside the house. Defendant also has some financial cards belonging to the alleged victim that he'll be delivering at the time that he obtains his property. And so I tried to note those things in the civil standby section. And unless the court has any questions for me, I think that's all I wanted to say.
Your Honor, just briefly, with regard to the assertion that there's no additional protection by the GPS monitoring. GPS monitoring not only provides notification if he comes within a certain distance, it also has the ability, in my discussions with the owner of 2Watch, to set off an alarm and essentially turn him into an alarm. It has an alarm that goes off if he were to violate, which provides warning to not only the victim, but those around him as well. And that creates a significant safety barrier.
It's like, woo, woo, woo.
So the parties are gonna hear me say something that I say quite often in these circumstances, but there's nothing that putting on this judicial robe does that gives me any insight into anyone's life that I don't have from looking at a police report.
His robe does not have special powers.
Very often judicial officers are scrutinized in hindsight, depending on the decision that they've made. And we make decisions with imperfect, limited information. My general use of GPS monitoring for victims is where there has been previous violations of a domestic violence no contact order, either historically or on an existing case. I don't see that in Mr. Webb's circumstances. That doesn't mean that GPS monitoring isn't something that's a good condition, but it means that I don't have anything that suggests that Mr. Webb will not follow the court order that I put in place. Now, Mr. Webb, you could catastrophically prove me wrong by violating this order and doing all kinds of number of things. I'm going to, at this point, assume based on your record that you're not going to do that. That said, if I have any indication that you're running afoul of the order I'm putting in place, I will not hesitate to quickly take action. Do you understand?
Sure.
So that said, the following are your conditions of release. You are to violate no laws. You are to appear at all mandatory court dates. You're to notify the court of any change of address or phone number. I'm releasing you at this time on your recognizance. I am imposing a no contact order. You're going to get a copy of that order today. Every time I issue one of these orders, I say the same information. This is a 6-page legal document. You're responsible for understanding all of it. It is not a defense to say I didn't know or didn't understand. If you're ready to engage in conduct and you are unsure if it will violate the order, use Mr. Wallace as a resource. Call him. Figure it out first before you take action. Do not find yourself back here with additional charges. Does that make sense?
Yes, sir.
You'll get copies of all the documents at the desk by the door. Once you have your paperwork, you are free to go. Thank you.
Hello? Hello?
Hi, my name is David from the marketplace. What are you doing today?
Good.
So God bless you. Actually, the reason
thank you.
of my short
too.
call is let you know. You too, sir. You're welcome. Actually, the reason of my short call is let you know that you already have insurance from marketplace, but still you never receive your benefits and your insurance card for the year 2026. Am I right?
You're right.
All right, not an issue. We can help you to provide that. Right now, which state are you living?
Which one am I leaving? California.
Yeah, which state?
I'm leaving California.
California. All right. All right. And you don't have any Medicare, Medicaid, TRICARE, job insurance, right?
That's correct.
All right. And how old are you?
I don't tell people over the phone.
You have a good day.
Hey, you too. Apparently he needs my age. Don't know why. He was polite about it, so I never know what to say. It was awkward. He's from the marketplace, like Facebook Marketplace, I assume. I should have asked him if he was calling about the car I had for sale. Let's see. We're still waiting for Judge Simpson to come back. Their people, his people need to have a little lunch. He gives them a very short lunch, only like 10 or 15, 20 minutes, and that's it. Let's see. Lamine, he is finished eating things. He's now on a sugar crush, and he's laying down. He's reclining. Mr. Laird is still waiting in the drive-thru for his order. It was a big order. It's going to be a while. And then we have a couple people who have just set their phones down on the desk to show us their ceiling. So how do they even make money? They wait for somebody who just gives them all the information. And then that particular scam, they transfer me to a legitimate insurance company that can help me get my market, whatever, my insurance that he's talking about, Medicare, whatever. But they transfer me there, but they stay in the middle of the phone call. They don't like actually send the call and then hang up and it's gone and I'm just dealing with a legitimate customer. No, they wait for me to provide my real information over the phone and they record all of that. And then they steal my identity. That's how they do it. So it's a volume game. It's all about numbers. If you try enough times, you're going to get somebody who maybe thinks it's real. Probably healthcare marketplace, yeah. Scammers are awful. I agree. All right, we're supposed to be going to lunch, but the judge said he's going to deal with this girl. Oh, Mr. Laird has his lollipop is on fire. It's smoking. I'm not sure if he knows this. But we are waiting for the judge to come back for the beginning of the next block. We believe that he's going to handle the issue. The issue is the disruptive girl that was in his courtroom earlier this morning after a case was handled. She was not happy with something that went down, and she was talking to the lawyer or her mom or somebody, disrupted court. The judge said, hey, knock it off. Come back up here. And she stormed out of court. He sent the bailiffs after her, captured her, cuffed her, and stuck her in the lockup. And so we're waiting to see how this resolves. Could be a learning experience. It could be the beginning to a long life in the court system, and maybe the jail. We'll see. I'm looking at all the different technology bets there are on Polymarket. Will Elon Musk be a trillionaire before 2027? 53% say yes. If you say yes as well, you could win $18.52. If you say no, you could win $20.41. But of course, it'll cost you $10 to vote. And then you have to wait till 2027. I just don't know. Just don't know how this works. It's just straight gambling. Which cities will Waymo launch in by June 30th? Hopefully not mine. Hey, what's up? Did you find them? No? Have you looked behind the printer? Or have you looked on the mantle in there? Have you looked underneath the printer? Like, looked in the basket? You guys, do you know where the red or the blue handled the blue handled clippers are for cutting the supports off of a 3D print? All right, that's for rich folks. Yeah. Depends on her attitude, how he treats her. I'm going to close out the poll. We've had a poll running a little bit. Will the judge give her a fine for her acting out in court? The results were yes, 60%, no, 40%. So the odds are not in her favor. Have you looked in the printer? They shouldn't be in the printer. Greener says to use your teeth. Don't use your teeth. It's Greener's. Let's see. Polymarket is kind of in limbo in the U.S. It isn't fully available. There's a wait list for rollout. Oh, like sign up? You can't sign up yet? I haven't tried to sign up. I just opened the website. All right. A little motion in the court, maybe? Possibly. Can we watch a replay of the disturbance? We did already, but I could pull it up again. It's very brief. There's not a lot to see, honestly. Where'd it go? My son is singing. That's nice. You can hear that, right? I'm trying to find the exact moment this happened. Can't find it. The bailiff's going out. Okay, here's what I have as far as the disturbance goes.
To the full moon.
What?
To the full moon.
Oh, this was
No.
after. Hang on. Let's try this one.
I'm not jumping.
Good.
Guys want to walk around?
Do you guys want to walk her out?
Young lady? No, come here. Come here. Oh, boy.
Oh,
Get her,
boy.
Mr. Allen.
Sicker. Get him. That's the disturbance. That was it. That's what happened.
Who is that?
So now we go back to live where it looks like the court's about to go back and possibly even bring that girl in. The court camera's live at least. Edward Gross is not happy that he's still here. Brittany Fisher's here. Let's see. Randall still waiting in the drive-thru.
I knew that. Yeah, that's why I just wanted to know. Yeah, they're like, it's not hard.
If this goes poorly, I feel bad for all the people in this block.
Wellness check. The clerk's just worried about it.
Super noisy in court today.
That's just what it is. That's our criteria. I don't know.
All right.
Here we go.
First thing, the district court of the county wants to announce that the Michigan is now back in session. The honorable Judge Greg Sedgwick.
You may be seated. Court does call the case. People versus Randall Laird.
Randall? Why Randall? Are we waiting till
Good
the end of
afternoon,
this
Your Honor.
block
Assistant
too?
Attorney General Clarissa Williams on behalf of the people.
Randall Laird, it's a PD case.
Public defender.
This case was complicated.
I think it's Miss Apple.
Yes, sir. Can you hear me?
Yes, I got you, Mr. Laird.
waiting for your lawyer.
Thank you, sir. I got you. I'm looking for your attorney.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Laird.
All right, what are we doing on this case?
Your Honor, we are asking for an adjournment. I have a sheet here. We are missing the discovery, all the discovery on this case. I did reach out to the Attorney General regarding that.
Any objection to the adjournment?
No, Your Honor.
All right. Probable cause conference will be adjourned January 29th, 2026, 9 a.m. as your invite indicates.
Bond will continue.
All right, thank you. Thank you, Mr. Laird.
Thank you, sir.
That is for the AG or no?
One more.
She has the next case also. Okay, she does. Court does call the case, People versus Tiffany Peters.
That's the Assistant Attorney
Good afternoon,
General.
Your Honor. Assistant Attorney.
And the court. Wow. They shut it down. Why would they shut it down? Hold, please.
That is for the AG or no?
One more.
She has the next case also. That is for the AG or no?
One more.
She has the next case also. Okay, she does.
Tiffany Comer, actually.
Yes, okay. And Attorney General.
Thank you, Your
Take
Honor.
care.
Here we go.
Court calls the case, People versus
Come on, YouTube. Don't do this to me.
Maya Hughes.
Maya.
Ms. Hughes, would you state your name for record?
would you state your name for record?
Maya Hughes.
Whatever other device you have.
Turn it off.
She hasn't turned anything off.
Judge, I just got this. I'm asking for adjournment.
I'm asking for it.
All right, go ahead. What?
I'm asking to adjourn this matter. I just got the discovery. I did forward it to Ms. Hughes, but I haven't had the pleasure of speaking to her about it. Is it possible to get the same day, the 29th?
You just sent her discovery and you
Being the
never talked to her
considerate
about
judge
it?
you are.
Didn't think that earlier.
I can't do the 29th. I have another court date the 29th.
Really?
At my client's pleasure, I will ask for another date.
Pardon?
I will ask for another date then, Judge.
February 5th, 2026, 9 a.m.
Thank you, Judge. Ms. Hughes will talk.
Court calls case People versus
Brittany.
Yakub Farah.
I bet it's Jacob.
On behalf of Mr. Farr, who's working out.
Well, my name's Yakub Farr.
It's Yakub.
Yeah, we can do it.
Okay, can you sign? Your Honor, I did discuss an offer that was extended for a waiver in this matter. Mr. Farah did wish to waive his right to preliminary exam, proceed to circuit court. He'll be entering a plea under HIDA and a dismissal of count 2, plead to count 1.
Here we go. Oh, this Caro's wrong. I have account 2. Anyway, I got it. All right, sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, proceed to circuit court for further resolution?
Yes.
People also waive their right?
Yes.
Preliminary examination, having been waived, defendants bound over to circuit court on both counts.
Your Honor, we acknowledge receipt of the information. My client, wait for reading. My client will stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
Second at 1:30 before Judge Hamud.
March 2nd, 2026, 1:30 before Judge Hamud.
Thank you.
Thank you.
Thank you. Bond will continue. One's gotta go. Court calls the case People versus Jacob Pike.
Good afternoon, Your Honor. Randy Cook.
Assistant Public Defender Hannah Appleton, on behalf of Mr. Pike, is approaching.
Your name?
Jacob Pike.
Take your hands out of your pockets.
Yes, sir.
What are we doing?
Your Honor, I believe that we will need an adjournment for Mr. Pike.
We don't know her name.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Fike.
Maybe he's making her wait all day.
Mr. Fike, I'm sorry. Yeah, yes, I'd ask for the court for a brief adjournment in this matter. I need to go over some things with
I need
Mr.
a
Fike.
green sheet, January
Yes.
29th, 2026, 9 a.m. Bond continued. Thank you. Right. Is
Oh, Big Sky. I'm sorry to hear that. That's no fun.
Fine. You don't need it. Whose case is it?
Is Legally Blonde here?
Joe.
Or is she out washing her car?
Court calls case People State of Michigan versus Elder Vasquez Sanchez.
People, Your Honor.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Vasquez Sanchez in his absence today. If counsel and I could very briefly approach, Your Honor.
If you're going to discuss the reason he's not here, I understand.
Okay, thank you, Judge.
So what do you wish for me to do? I can adjourn it out.
Give me a raise and a dismissal. No, I think that's
Just adjourn it
appropriate.
out.
Figure it out.
Yeah.
You guys can, okay. Probable cause conference will be adjourned to February 5th, 2026, 9 a.m. Bound continued.
Your Honor, both Mr. Vincent and myself are in a trial in a death case on Third Circuit that day. If we could do any
So there's
day.
some other judge that's going to be painfully,
Yeah,
they're going to have
for days at a time too. I mean, if you want to send flowers, I'll tell
it's going to
you.
be
And Your Honor, if I may, we may not even need to come back on that
Right.
today, so I think we can set it for that day, and council will not.
That's fine as well. We can always skip if we have. to.
Okay, that took a lot longer. All right.
As always, Judge.
Thank you. Court calls the case, People versus Jacob Halfacre.
And good afternoon, Your Honor. Joseph Hall appearing forward on behalf of Mr. Halfacre, who's now standing to my right. Mr. Halfacre, if you could state your name for the record, please.
Jacob Halfacre.
Thank
I wonder if he
And Your Honor,
owns
we're
it
in active
hand.
negotiations with Mr. Chabalowski. We've had some
cool
productive
name.
discussions and feel like there is a reason to request that the court adjourn for further negotiations.
29th be enough time for it.
I would think so.
Yes.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continued.
Thank you.
All right. Thank you.
Thank you, Chief. Thank you very much, Your Honor.
Thank you. Court calls the case, People versus Brittany Fisher.
She wants to be sworn in. She has the flag.
Product Quickland on behalf of Ms. Fisher, she should be on Zoom.
Ms. Fisher? Oh, there she is. State your name.
Yes, I'm Brittany Fisher.
Thank you.
Your
All right, what did
Honor, we're requesting a adjournment on this matter.
Green sheet.
Thank you.
Probable cause conference in this case, January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Brittany writes it down with her pencil, which she brought to court. She read the instructions.
Court calls case, People versus Ashley Floyd.
Good afternoon, Your Honor.
Assistant Public Defender Chelsea Virgils with and on behalf of Ashley Floyd, who appears via Zoom. Please unmute and state your name.
State your name.
Ashley Floyd.
Thank you.
Yes, sir.
I have a green sheet. We are asking to adjourn to receive media and continue our discussion.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the People versus Alan Fife.
Mr. Gross keeps shaking
Michael
his head.
Gaddy, Assistant Public Defender on behalf of Mr. Fife, who's approaching judge.
Are we doing them alphabetically? I didn't listen to the names. Gross
Your
might
name,
be
sir?
next.
Alan Fife.
All right. You're requesting an adjournment in this one.
Yes, Your Honor.
Green sheet.
I believe Mr. Fife may be a good candidate for the Specialty Veterans Court.
Probable cause conference, February 5th, 2026, 9 a.m. Bond continue.
Thank you. Your Honor.
Thank you. Thank you, sir.
Thank you, Your Honor.
Court calls the case, People versus Aaron Grable.
Assistant Public Defender Jim Hollinger on behalf of Mr. Grable, who should be appearing via Zoom, Your Honor.
Grable?
There he is.
Oh, there he is. State your name.
Aaron Grable.
Thank you.
Ooh, good
Your Honor, we
voice.
are just asking for a brief adjournment. I anticipate that this is going to end in a nully, so we just need a couple weeks to figure the rest of that out.
Cross.
January 29th, 2026, 9 a.m. Bond continue.
Mr. Gross,
Thank
put your
you.
hand down. You're next.
Thank you, Mr. Grable.
Thank you.
Court calls case, People versus Jesslyn Gray.
Nope. Sorry.
Andrew
Just
Thomas appearing on behalf of the people.
Assistant Public Defender Don V. Lebo on behalf of Ms. Gray, who appears via Zoom. Ms. Gray, could you please state your name, ma'am?
Jesslyn Gray.
Thank you.
And Your Honor, we'd like to
Change it
please
from
set this
Jessica.
matter for preliminary examination. Discovery is complete.
People have their witnesses available the 20th.
That's fine.
Preliminary examination in person, January 20th, 2026, 9 a.m. That is in person before Judge Moore. Bond will continue.
Thank you, Your Honor.
all right. Now, Edward.
Court calls the case, People versus Edward Gross.
There you go, Edward. It's like it's about time. You have to mute, dude.
Chelsea.
I don't know.
Mr. Gross, can you, he's
Assistant
on.
Public Defender Hannah Apple appearing on behalf of Mr. Gross.
Mr. Gross, can you state your
I
name,
spy a
please,
belly
sir?
button.
Hi, Edward Gross.
All right, thank you.
How are you doing, sir?
Huh?
How
I'm
are you doing?
Great. I'm doing great. Thank you.
Good, good.
Okay. Your Honor, we're asking for an adjournment so that we can have some further discussions with our client.
Probable cause conference, January 29, 2026, 9 a.m. Bound continued. Thank you, Mr. Gross.
Thank you, sir.
Calls case People versus Suzette Hampton.
Yeah, Assistant Public Defender on behalf of Ms. Hampton, Your Honor.
Who should be on Zoom. Nope, here she comes. She's coming from the gallery.
Hello, state your name.
Suzette Hampton.
Thank you. What are we doing?
Your Honor, we'd ask the court to set a preliminary exam.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 20th.
What does it say? Gamer girl, try to keep up.
Preliminary examination in this matter will be set in person. January 20th, 2020, 9 a.m. For Judge Fresh Hour. Right here. Bond continued. Thank you. Court calls the case People versus Dustin Hufford.
Assistant Public Defender Chelsea Vergils.
The
With and
sign's
on
from
behalf of
Hobby
Dustin
Lobby.
Hufford, please state your name.
Dustin Hufford.
Your Honor, I have a green sheet for this one as well. We're just asking to adjourn so I can discuss things a bit more with Mr. Hufford.
January 29, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
I'll give you a call.
Court calls case People versus Roger Jacobs.
Assistant Public Defender Jay Ballinger on behalf of Mr. Jacobs to approach us. Mr. Jacobs,
Good morning. State your name.
Roger Jacobs.
what's that look for?
Huh?
What's that look for?
What look?
You're giving a look.
Because I was going to tell him my package was late.
He's an Amazon delivery driver. The gamer girl
All
sign
right,
in the
here,
top right
that's
hand
why.
corner.
Never heard that.
Oh, because you had to be here. Sorry. We inconvenienced a bunch of people, right? Okay.
Your Honor, my client was just made an offer. He'd like some time to take it, to consider it. So we're just asking for 2 weeks.
Try to keep up.
January
Hobby Lobby.
29,
Not a sponsor.
2026. 9 a.m. whereas the invite indicates bond will continue. All right. Thank you, sir.
Thank you, sir.
Thank you, Your Honor.
Good day now.
We'll be in touch.
Have a good day. And drive safe.
Sure.
I want one of those blue trucks.
You and
I
me
don't have to
both,
put
Judge.
anything in it. I'm just going to drive it around.
Park
Makes
wherever
people
you want.
happy. Court calls the case of People versus Adonis Johnson.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Johnson, who's approaching Judge.
Your name?
Adonis Johnson.
The wood paneling is
Yeah,
from
I've
the
had a chance
70s.
to go over this matter with the prosecutor, with Mr. Johnson. We got the court for a very brief adjournment to continue discussing this matter. There's also some body cam I'd like to review.
Oh, this body cam. That's what the.
Or if ironic, it might be Bubba Gaddy.
Yeah, I don't know what. I was trying to figure out what that was, but I got it now. All right. Probable cause conference in this case. I'll adjourn this one to February 5th, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
Court calls case People versus Anthony Johnson.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Johnson, who should be appearing via Zoom.
Mr. Johnson, Anthony Johnson, need to unmute, turn your camera on.
Michael Trowbridge gifted 5 memberships. Thank you, Michael.
State your name, sir.
Anthony Johnson.
Thank you.
Your Honor, I did submit a referral to our mitigation team to have a report completed. So if we could have a few weeks,
Okay.
I'd appreciate that.
Probable cause conference,
You need to close that cupboard
February
door.
February 5th. 2026, 9 a.m. Bond will continue.
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome, sir. Court calls case, People versus Ethan Jordan.
Good afternoon, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jordan, who approaches Your Honor. And can you state your name?
Jordan?
And Your Honor, Mr. Jordan, we did stip to adjourn this off the record so that Mr. Jordan could hire U of M Legal Services for this matter. He has been able to do that. They were shut down during the holidays. They just need to do a substitution of attorney. So I'm just asking for 2 weeks so that they can get on this case.
Probable cause conference, 22nd. January 22nd, 2026, 9 a.m. Bond continued.
We set at 9 a.m. right now, but your attorney should be able to call the court the real time. Okay. All right. Just take care of the buck.
All right. Miss Journey's next. We're waiting. We're waiting. Still waiting. Can we bring that girl in, Judge? Hey, what'd you make me? You made me ramen? A plate full of ramen for my son. Fresh from the microwave. Thank you, bud. Appreciate that. He loves ramen. He assumes everyone does. It's not my favorite. But I'm not going to tell him. All right. Kalisha, keeping some notes. Lamine is hungry again. Going for the belly button reveal. But he lets it slide.
Court does call the case of People versus Kalisha Journey.
Kalisha, gamer girl, you're up.
Regina's, where is she?
Assistant Public Defender Hannah Apple appearing on behalf of.
We're going to cuff Regina's to the podium.
What was that? Oh. Took a minute to process what you said. That's okay. Miss Journey, can you state your name for the record?
Alicia Journey.
She's not a gamer on that internet connection. Should have a ping of 200.
Her last name on the file needs to be amended and on the complaint. And it's actually just her last name. Because we have it on the complaint as Journey. There should be an A after the E and before the Y. Is that right, ma'am?
Yes, sir.
All right. So is there any objection to the amendment of the complaint regarding her last name?
No, Your Honor.
Do that right now. Ugh, I can find it.
Thank you.
You're welcome. What are we doing on this case?
I have a green sheet, Your Honor. We're asking to adjourn so that Ms. Journey can review the media discovery.
For her media discovery?
We have it. She wants to do it.
Yes. Got it. All right, then I will adjourn this one to the 29th of January. 2026, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
Thank you, ma'am.
Thank you.
Still trying to find my complaint. Court calls case People versus Vincent Julian.
Good afternoon, Your Honor. Raymond.
Stephanie Can on behalf of Mr. Julian.
Are you here? I don't have him on.
Your Honor, he would not be present by Zoom, at least not at this time. It is my belief and understanding that Mr. Julian is currently being housed at the McLean Jail in Minnesota with anticipated transport to a prison in Minnesota. So he would not be present by Zoom today.
It's not said that way.
Oh,
Minnesota.
Minnesota.
Say it right.
So we are going to ask for an adjournment of this case to see if he can be written here.
Probable cause conference, February 12th, 2026, night. Continue. I'll give you the adjournment rather than issue a bed. We'll start.
Thank you, Your Honor.
Calls the case People versus Lamine Kaba.
Senator Donahue Lebo for Mr. Kaba, who appears via Zoom. Mr. Kaba, could you state your name, sir?
Lamine Kaba.
Thank you.
And Your Honor, we're here for a competency hearing today. I'm not in receipt of a report from the Forensic Center. Senator,
I don't have a report either.
and Mr. Kaba has had his appointment.
He has?
Yes.
Okay. Then.
And I do have a green sheet.
I'll adjourn this out.
Oh, I'm sorry, that was the wrong sheet.
Where I'm kind of putting these. I'll adjourn it out to February 26th. We may move the date up if we get the report before then.
Thank you, Your Honor.
February 26th, 2026, 9 a.m. Bond will. Thank you, Mr. Kaba.
Thank you.
That's called the case of the People versus Mohammed Kaba.
Stephanie Can on behalf of Mr. Cabo, who is approaching. Mr. Cabo, could you please state your name for the record?
Mohammed Kaba. Thank you.
Your Honor, we're asking for an adjournment of this matter. Just
sure.
if we can get some sort of negotiations going on.
January 29th, 2026, 9 a.m. Bond continue. Thank you. Joe Hoskin, yeah, in Arbor today.
The other person in this pocket is in. That's all I have for now.
Other one.
It's blocked.
Are we going to bring her out? Is this the moment? We're all waiting to see what happens. Okay. Mic on? Court calls the case of Judge. Come on. Turn the sound off and I left it off. This will be the biggest. We waited here for hours.
Hello.
Hello, hello. Mike, Judge, Mike, there you go. Thank you.
Call case of the people versus Tebby and Lewis.
Good afternoon, Your Honor.
Yeah, he's here, public defender on behalf of Mr. Lewis, who's approaching.
Oliver Hernandez is showing us his.
Your name, sir?
Tavian Lewis. Your Honor, we're asking for an adjournment. There was there's some body cam. There was some problem with the sound. I was able to, troubleshoot my computer and fix it, but not in time for today's hearing.
I can't even
January
see his face.
29, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Court calls case people versus Diana Lewis.
And back on behalf of Mrs. Lewis and Zoom.
Is she on Zoom?
Miss Lewis.
I haven't seen her.
Tebby Lewis.
Bench Warren.
Diana Lewis, excuse me. Diana Lewis. And
Your Honor, I'm asking to adjourn this matter.
okay. And court will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you.
Calls case people versus Tricia Lopez.
Brian Bowling on behalf of Mr. Lopez, or Miss Lopez, excuse me.
Hi,
Speaking
Tricia
of the record.
Lopez.
Thank you.
Your Honor, I'm asking for an adjournment so I can review
That's
discovery
confidence.
by
Bard.
myself and with Miss Lopez.
Barge is right by her attorney.
Probable cause conference, February 5th, 2025, 26, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Your Honor.
Excuse me. Court calls case of the people versus Tina Mageria.
Good afternoon.
Brian Bowling on behalf of Miss Magira.
Magira.
I like his.
I was wondering whether to make G. Well, anyway, I get it.
Tina McGear.
Judge, I'm asking that this matter be set for a preliminary examination. All discovery is complete.
And would the people have their witnesses available the 20th? Preliminary examination in this matter will be set in person January 20th, 2026, 9 a.m. before Judge Breshow. Bond will continue.
Thank you, Judge.
Court calls case of the people versus Khalid Mahmood. Excuse me.
Assistant Public Defender Chelsea Virgil with and on behalf of Khalid Mahmood. Please state your name.
Khalid Mahmood.
Thank you.
I have a green sheet. We are asking to adjourn for media discovery.
Now she has a green
Media
sheet.
discovery.
Yes, Your Honor.
29th, January 29th, 2026, 9 a.m. Bond continue.
Thank you, sir.
Court calls case people versus Deland McMullen.
Good afternoon, Your Honor.
Afternoon, Judge Mike Gaddy, Assistant Public Defender on behalf of Mr. McMullen. State your name, sir.
Deland McMullen.
Thank you.
Your Honor, I have had a chance to go over this matter with Mr. Cook and with Mr. McMullen. The people have made an offer. I'd ask the court for a very brief adjournment so that I can for that offer with Mr. McMullen in some detail and discuss.
Judge. Don't do this to us, Judge.
Ask the court for a very brief adjournment so that I can go over that offer with Mr. McMullen in some detail and discuss. There's some body cam. There was some problem with the.
Hang on.
Ask the court for a very brief adjournment so that I can go over that
He's
offer
gone.
with Mr. McMullen in some detail and discuss.
Judge Cedric Simpson, YouTube. Greeners. Is this one on you?
Ask the court for a very brief adjournment so that I can go over that offer with Mr. McMullen in some detail and discuss.
And it's gone. And discuss, and it's gone. Just like that. Greeners, you got one job. One job. He killed the feed. He killed the feed. We don't get to know. Did someone cut your fiber? Think it was copper? No. My internet's still up and running fine. It's the judge that turned off his live stream. Trying to see if he'll bring it back up for this next little clip, but apparently he knew it was going to go viral and he has some things to say and he doesn't want the internet to know about it. Well, on that note, Judge Simpson, we waited so long. I know. Judge, how can we possibly get educated on proper courtroom etiquette if you correct any problems in private? We need to hear. We need to know, and we have waited patiently. This one doesn't work very well. I'm just squishing the goat. It won't scream. With that, we have to go to lunch. I've already had some ramen, but I'm hungry for some good, nutritious food. How could he do that to us, Judge Simpson?
Ask the court for a very brief adjournment so that I can go over that offer with Mr. McMullen in some detail and discuss.
Is the weather bad up there for you Michiganders? Is it bad weather? Is there some excuse that we can give him, holding him in contempt? Spin the batteries. Always works for at least 5 more times. Weather's really good, actually, says JMR. See, it's on the judge this time. It's on the judge. I'm not buying this gamer girl sign. He restarted his stream. Well, let's see if we got it. There it is. Let's go over here. Let's see if we can find it. Judge Simpson. Let's go back to the beginning. Take 8.
Or with Mr. Mopkin.
Mopkin? Yes. Just in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public.
Yeah, let's jump back here.
Just in reference to this case, we'll call it in regard to the Mopkin matter. The defendant does not need to be present and is not present. I think Joy was.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of the respondent, defendant. I don't.
Yeah, yes, she would be responding. Your name, ma'am?
Sequoia Jones.
Ma'am, you know why I held you?
Yes,
Tell me what your thought is on why I did.
because I disrupted your courtroom.
Yeah, you disrupted the courtroom, and then when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was a little too much. It was my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But
Your mom's coming back in a week or two, right?
That's correct, Your Honor.
Huh?
That's correct, Your Honor.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was asking
Can I
her.
just say this?
Oh, okay.
You need to let the attorneys do their job. Okay? You have an issue to the extent that they'll even talk to you. If you have an issue with them, then you deal with that outside of this courtroom. So should I banish you from coming into this courtroom again?
No.
You think you can conduct yourself?
Yeah. Yes.
Young lady, I'm going to give you another chance. If you come back in here and act the way you did, I'm going to guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
Yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't
Oh,
raised
you
that way.
were today.
I was today, but I'm not.
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything to you. Right?
Mm-hmm.
So just check yourself next time before you come in here. All right, we can release you. Let her go.
Thank you.
Check
Thank
yourself
you.
before you wreck yourself.
Quarter stand in recess.
Let her go.
and I
No
guess
fine.
We'll come back and do our 2:00 block and on.
No fine, no punishment. Judge, appreciate you coming back. I said some harsh things about you, about not wanting to share what was actually going on, but you fixed it. You fixed it. So she'll learn. I think she learned. He's a bit of a softie. No 93 days. I was right. No punishment. What about Mr. Allen? Did she disrespect me? She disrespected everybody. All right. We take it all back. We take it all back. So I guess being locked up is sufficient punishment. I think she was probably locked up for, I don't know, 20 times the amount of time she actually disrupted court. So it's a good sentence, I think. I think that'll teach her. No hard feelings. Thank you very much, Greeners. We have closure. I feel so much better going to lunch knowing what happened. Camilla Juliana, I did get your videos of you watching Waymo. Unfortunately, they have videos and audio, I think, from the Waymo that might be copyrighted by Waymo. I can't play them. Like the instructions about staying seated and remaining in the car and everything. But I tell you, it does look rather freaky to watch a car moving from the back seat and seeing nobody in the driver's seat. It's crazy. It's futuristic. I've never done that, but looks cool. Thank you for the videos. The Red Pen, thanks for passing those on. Better be good before you get a summons. I know. Well, he doesn't have subject matter jurisdiction. As long as they stay out of Michigan, he can't get me. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again this afternoon with a little bit of court hopping. This is Thursday, which means it is Podcast Thursday. It is the first podcast of Season 4. Season 4 coming at you. That'll be tonight. Thomas and I will be here, so please join us. I think we have some membership gifts to give away because we did not do it last week. We didn't have a New Year's Day podcast, so are we coming back today? We are. I just haven't made the link yet, so I'll do that right now. If I'm fast enough. It's going to be close. Schedule stream. I'm not fast enough. We're just going to let the music play out, and I'm just going to still be here. Setting up everything the way it needs to be for the jump. What time is it now? It's 2. We're going to come back at 2:45 if that works. Short lunch. New one is up. Wait for it. Now I have to create the link.
Hello.
Go back here. I probably spelled something wrong, so just ignore that.
The zombie apocalypse may be upon us.
Redirect. Portals created.
There's nothing in the order that restrains you from talking to cats.
Nothing in the order. All right, you guys. Sorry, I turned my mic off. You guys be good. We'll see you after
Thank you,
lunch.
sir. You're my new best friend.
All right. Bye.
I got a stubby little pencil